Shankaranaran, you are on which side?
He is always here.
No.
This-
Whether you are on a fence or
Genuinely, personal opinion, one shouldn't take extreme position.
Who are you appearing for?
Where the
Intervenable.
interventions have been allowed on the first place.
no.
We are giving advice to the President of India. I think we
No,
should-
not we. Court. The court is giving. Yes, sir. No. No, the 143 empowers only the court to give advice
Then
to the president.
But then without your assistance, we cannot give our advice.
Assisting the court. My lord. We are not advising the government. Yes.
Well, may I just put this down because we can't see your lordship, Mullah. We'll put it back, Mullah, at the end of it.
Even
Look.
the learned, the solicitor.
Yes.
We will
And-
not put it back as long as the CV goes on.
Your lordship, because here there is no petitioner and respondent. And genuinely, I am saying this, my lord, without any other meaning. Mr. Sibbal, my lord, I am looking forward to his arguments because he has been a parliamentarian. He has been an elected person answerable to the people. And my lord, we know
So he has been a person answerable to the parliament also.
Parliament, that's why I was coming to that he was also in the governance and how it affects the governance when I come to, my lord, the question of judicial review or, my lord, justiciability. Because people, your lordships are aware of late, my lord, since last 20-25 years, my lord, you cannot take a voter on ride. They catch the elected people.
You cannot.
Take voters on a ride, which earlier used to happen. They catch you that I have this problem, you are not solving me. And that is why, my lord, I always say that irrespective of the color of the political party, an elected person cannot be denounced that he is just an elected person. And
But who says that?
I will show. I'll show who said that, my lord. I'll not going into. Your lordships have not said. Your lordships have not said, my lord. But I'm going to show that. But they are answering.
I have always said that
My lords have always said. I have
separation of power and
this bench. I'm not referring to, my lord. When we say
I have so many times deprecated I have said that the judicial activism has to remain, but it should not turn into judicial terrorism or judicial adventurism.
terrorism or judicial
Adventurism.
adventurism, my lord. That's correct, my lord. And as rightly submitted by Mr. Shankar Nayan, we are to assist your lordships, my lord, and your lordships will give the opinion. My lord, so far as yesterday's argument, my lord, which I will not stretch it beyond it because I know your lordships have got, my lord, what is my interpretation
Yes,
of
sir.
Article 200, but I have tried to, my lord, kind of calibrate it, my lord, so that instead of, my lord, is better, my lord, explained by me the way I am reading it. And it's very easy chart, my lord. It would not. Sorry. My apologies. I thought I had given. Yes,
Share it.
I can share digital also. Share digital also. Rest of it is shared with on digital, this thing, for rest. Oh, your lordships, my lord, kindly, my lord, bear with me only for 5 minutes and I'll switch over to the next point. The governor shall declare, I'm not repeating declaration has its meaning, it's a constitutional declaration. He has 3 options. First, let us come to the first option, grant assent. Now, what are the facets of granting of assent? Lord, please see the left-hand side route which the governor can take. At the outset, he grants assent. The bill becomes an act. Correct, my lords? But he can defer grant of assent and take a decision to resort to the proviso, that is returning the bill to the House. That is the 4th option in the proviso. Bill is returned by the House to the governor with or without modification. Then he will have 2 options. Lord, if your lordships can. Then he will have 2 options. He can grant assent. That's all right. My recommendations or whatever.
We have gone through the chart. These only depicts what you argued yesterday.
My lord, but my lord, second, my lord, let me at the cost of repetition show what is second. Second is a withhold option, which in my submission is a standalone option, and it is a complete action of the constitutional functionary.
So according to you, Punjab has been wrongly decided.
Yes, my lord, but he has a choice. My lord, right side, at the outset, if he withholds for, my lord, reasons, my lord, which I have explained, some things is so patently unconstitutional or something going against the nation or clearly in the first schedule, etc., then the bill falls through. Now the question was, instead of, this is where instead of comes. Instead of taking this route of at the outset withholding, resorts to the proviso instead of withholding. Then, my lord, it is returned to the house. And if it comes back, he will have two options, my lord. He will grant assent that, okay, I'm bound because I cannot now withhold because I have resorted to the proviso. Or he can reserve the bill for consideration of the president. My lord, third is there is one new element which, my lord, which I have, and there cannot be any dispute on this element. When he reserves the bill at the outset for the consideration of the president, for presidential assent, my lord, first can be in case of repugnancy. If he feels that it is repugnant to some central law, he will refer it. Second column, my lord, which is a bigger column, your lordships need not read. There are certain provisions in the constitution itself which mandates that if your state legislature is passing this law, mandatorily presidential assent is required. It's nobody's discretion, neither governor nor council of ministers, nobody. My lord, for example, Article 31(3), 31A, before amendment, then second proviso to Article 2, so and so, so and so, so and so. There are several provisions. Or any other reason, my lord, which he feels that I want to reserve it for the president. Lord, this is what my lords also, my lord, were pleased to, my lord, indicate. This is just to, my lord, calibrate it, my lord, and put it in a comprehensive manner. But all four options are independent of each other. At least 1, 2, and 3 are independent, with an option to resort to option 4, not a mandate to resort to my lord, option 4 as decided in Punjab. So that is my case, my lord. Now, my lord, may kindly come to page number.
Second one is you can choose to resort to the your arguments. You have
That argument is over. I'm coming to the next argument. Well, there are some judgments which I have cited, how proviso is to be interpreted, but I don't wish to cite it here. It's a fairly settled proposition, and your lordships are fully aware. It is cited for ready reference.
very well-known phrase.
Yes, yes. So page 187. Malad, this is the second question, Malad, which I am addressing. The first part is over. 200 and 201 is over. Whether governor is bound by the aid and advice tendered by the council.
That is page number?
187, Malad, of my written submission. So PDF page also same.
PDF page is there.
Your lordships have
Yes.
PDF page or the physical file, my lord. I can accordingly. The PDF page is 94. Para 166, my lord. जब मैं आऊं तब याद करो जब वहां पे पहुंचू तब याद करो Lord, the question is whether the governor is bound by aid and advice of the council of ministers, my lord. Lord, 163 I have read, my lord. I'll read the first part, 163(1), so that, my lord, for just immediate reference, there shall be a council of ministers with the chief minister at the head to aid and advise the governor in exercise of his functions, except insofar as he is by or under this constitution required to exercise his discretion or any of them in his discretion. Correct, my lords? So functions can be discretional, based on discretion, or as per aid and advice. My lord, what is the demarcation? That is the question, my lord, before your lordships, my lord. My lord, here, minimum, my lord, I'll skip what is not relevant, but the minimum constituent assembly debate, my lord, which is relevant for your lordships to consider the question, my lord, is at page 187, bottom. Lord, Mr. Kamath objected this discretion, and it was answered by Mahavir Tyagi. Lord, please have a look at Mr. Kamath's objection. When you, sir, raised a very important issue the other day, Dr. Ambedkar clarified this clause by saying that the president is bound to accept the advice of his ministers in exercise of all his functions. But here, Article 143 vests certain discretionary powers in the governor. And to me, it seems that even as it was bad enough. But now, after having amended Article 131 regarding election of the governor and accepted nominated governors, it would be wrong in principle and contrary to tenets of principle of constitutional government, which you are going to build up in this country. It would be wrong, I say, to invest a governor with these additional powers, namely discretionary powers. I feel that no departure from the principle of constitutional government should be favored except for reasons of emergency, and these discretionary powers must be done away with. I hope this amendment of mine will commend itself to the House. Then, my lord, this argument is responded to by Sri Mahavir Tyagi, lord, which is here. I beg to differ from my honorable radical friends, Mr. Kamath and Professor Shiban Lal Saxena. And I think the more powers are given to provinces, the stiffer must be the guardianship and control of the central in the exercise of those powers. That, in my view, we have now given up the idea, the old idea of creating autonomous states, and are now keeping a reserve of powers in the center, and we are going to have nominated governors. Those governors are not to be there for nothing. After all, we have to see that the policy of the center is carried out. We have to keep the state linked together, and the governor is the agent, or rather, he is the agency which will press for and guard the central policy. In fact, our previous conception has now been changed altogether. The whole body politic of a country is affected and influenced by the policy of the center. Take, for instance, subjects like defense involving questions of peace or war, of a relationship with foreign countries, of our commercial relations, exports and imports. All these are subjects which affect the whole body politic, and the provinces cannot remain unaffected. They cannot be let free of the policy of the center. The policy which is evoked in the center should be followed by all the states. And if the governors were to be in the hands of provincial ministries, then there will be various policies in various provinces, and the policy of each province shall be as unstable as the ministry. For there would be ministries of various types having different party levels and different programs to follow. Their policies must differ from one another. It will therefore be all the more necessary that there must be coordination of programs and policies between the state and the central government. The governor, being the agency of the center, is the only guarantee to integrate various provinces or the states. The central government also expresses its thought, itself, through the provincial states. Along with their own administration, they have also to function on behalf of the central government. A governor shall act as the agency of the center, and we'll see that central policy is sincerely carried out. Therefore, the governor's discretionary power should not be interfered with. Democratic trends are like a wild beast. Say what you will. Democracy goes by the whims and fancies of parties and the masses. There must be some such machinery which will keep this wild beast under control. I do not deprecate democracy. Democracy must have its way, but do not let it degenerate into chaos. Moreover, the state governments may not be quite consistent in their own policies. Governments may change after months or years, with them will change their policies. The governors may change too, but the policy and instructions given by the center to the governors will remain practically unchanged. The more the powers given to the states, the more vigilant must be the control. The governor must remain as the guardian of the central policy on one side and constitution on the other. His powers, therefore, should not be interfered with. He is not for nothing. He is not just a showpiece. My lord, thereafter, your lordships may kindly turn the page, my lord. Pandit Thakur Das Bhargav, my lord, continues the discussion. Sir, I beg to propose the amendment of oppose the amendment of Mr. Kamath. Under Article 143, the governor shall be and in the exercise of his functions by the Council of Ministers. It is clear so far. मुझे देना ये कुछ कट गया है मेरा. Article 143, governor shall be aided in the exercise of his functions by a council of ministers. It is clear so far. I gave notice of an amendment which appears on the order page at so and so, which I have not moved. In that amendment, I have suggested that the governor will be bound to accept the advice of his ministers on all matters except those which are under this constitution required to be exercised by him in his discretion. My submission is that it is wrong to say that governor shall be a dummy or an automation. As a matter of fact, according to me, the governor shall exercise very wide powers and very significant powers too. If we look at Article 144, it says the governor's ministers shall be appointed by him and shall hold office during his pleasure. So he has the power to appoint his ministers, but when the ministers are not in existence, who shall advise him in discharge of his functions? There can be a vacuum. One ministry goes, another has not been installed. My lord, in that context.
Whenever there is a president's rule,
Yes, yes.
there are advisors to the governor.
Correct, my lord. They're appointed by the center. But can we read further?
In the vacuum also, normally if one CM resigns, or if he loses the majority till the new CM takes, he acts as a caretaker chief minister.
No, sir. Kindly, my lord, have a look at this one. Suppose, my lord, the tenure has gone. The governor tenure doesn't go. The new election takes place. It is considered, my lord. And it is considered subsequently in judgments also. My lord, 7 judgment, my lord, considers this aspect. Then again, when the governor calls upon the leader of a party for the choice of ministers after a previous ministry has been dissolved, in that case, there will be no ministry in existence, and who will be there to advise him? Therefore, he will be exercising his functions in his discretion. It is wrong to assume that the governor will not be charged with any function which he will exercise in his discretion. Article 175 and 188 are other articles which give him certain function which he has to exercise in his discretion. That is Article 200 and 188 is emergency powers. My submission is that according to me, the governor shall be a guide, philosopher and friend of the ministry as well as people in general, so that he will exercise certain functions, some of which will be in the nature of unwritten conventions and some will be such as will be expressly conferred by this constitution. He will be a man above party and he will look at the ministry and government from a detached standpoint. He will be able to influence the ministers and members of the legislature in such a manner that the administration will run smoothly. In fact, to say that a person like him is a mere dummy, an automation, or a dignitary without powers is perfectly wrong. it is quite right that so far as our conception of a constitutional governor goes, he will have to accept the advice of his ministers in many matters. But there are many other matters in which the advice will neither be available, nor will be bound, nor will he be bound to accept that advice. My lord, thereafter, my lord, Dr. Ambedkar's speech, which I have read, my lord, in a different context. So, my lord, I am not reading it here, but he, my lord, substantially echoes the Mahavir Tyagi view and the view of Pandit Thakur Das. Now, my lords, may kindly come to Lord, I have quoted Sirvai, my lord. If your lordships can come to, I will not read it. Page 192. My lord, what are the discretionary powers of the governor and the president? My lord, Sirvai has, my lord, H.M. Sirvai has elaborately dealt with, my lord. I may not read it. Your lordships may kindly read it. It would, my lord, really assist your lordships. Now, please come to, my lord, 194. Lord, these are the judgments on the question of discretion. Lord, please see 188 at the foot of page 194. It is, your lordship gets that. No? It is 194.
What?
194. PDF is 101. Para 188. It is submitted that this honorable court has carved out an exception to the general rule of the aid and advice, which is not expressly stated in the Constitution, however, which is in consonance with the intent of framers of the Constitution of India and also with the scheme of functions and powers of governor provided therein. A reading of the judgments discussed below and other provisions of the Constitution of India would show that inter alia, the following are the exceptions to the general rule of aid and advice, where the Constitution expressly provides for the same. For example, Article so-and-so, 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 where he will not be bound by the aid and advice and there cannot be any dispute. These are constitutional mandates. B, where the legislative intent emerging from the interpretation of any provision of the Constitution, like the powers under Article 200, 356, or the power to dismiss the government which has lost confidence but refuses to quit, as has been mentioned in the report of Justice M.M. Punchi Commission and have been concurred by a 5-judge bench of this honorable court in Nabam Rebia. I'll read, my lord, very illuminating paragraph of Nabam Rebia, where the constitutional courts specifically declare that certain functions ought to be exercised by the governors on his own. My lord, your lordships have developed this law, my lord, by judicial decision making. Power to summon or prorogue the House of Legislature, Legislative Assembly under Article 174 when there are strong reasons and material to show that incumbent Chief Minister and his Council of Ministers seem to have lost the majority of the House. Then situations or matters where the bias is inherent in the aid and advice of Council of Ministers, like the case of grant of sanction for prosecution of Council of Ministers. 197 sanction or Section 17 PC Act goes before the governor, my lord, in case of chief minister, then obviously he would not be guided by the aid and advice, and MP judgment, my lord, I'll show that makes it very clear. Now your lordships may kindly see, my lord. This is, my lord, Lord, I'll skip that judgment. Please come to 197, Samsher Singh. Samsher Singh, my lord, is a 7-judge bench judgment. At the outset, I may point out that Samsher Singh's 7-judge bench judgment is taken note of in state of Punjab versus Union of India, but the relevant paragraphs appears to have missed. It doesn't take care of the relevant paragraphs. I can, my lord, make that statement, my lord. If it is challenged, my lord, we can show it from the, it's not there, my lord. I can't, my lord, in state of Punjab versus Union of India, the 3-judge bench, my lord, 2024 judgment, takes note of Samsher Singh, but it has escaped the attention of the bench of these two paragraphs, which according to me is the real law of them. Lord, your lordships would find, my lord, that judgment at page 11669. Just put a note, my lord. That judgment, my lord, volume 5.29, judgment starts at page 11660,
Punjab volume,
volume 5.29. At page, it starts at page 11660. Shamsher Singh is cited at para 16,
para 16.
16, at page 11669.
1 minute.
Not only two paragraphs are noticed. The lordships may come to 11669. My lord Justice Narasimha has, my lord. Para 16, my lords have. My lord the Chief Justice.
Does it start from 11660?
It starts from 11660, but I am at 11669, where Shamsher Singh is noted. These principles have been well established, your lordship gets, my lord, since the decision in Shamsher Singh versus State of Punjab, where this honorable court held, under the cabinet system of government as embodied in our constitution, the governor is the constitutional or formal head of the state, and he exercises all his powers and functions conferred on him by or under the constitution on the aid and advice of his council of ministers, save in spheres where the governor is required by or under the constitution to exercise his function in his discretion. It is a fundamental principle of English constitutional law that ministers must accept responsibility for every executive act. In England, the sovereign never acts on his own responsibility. The power of sovereign is considered by the practical rule that Crown must find advisors to bear responsibility for his action. Those advisors must have the confidence of House of Commons. This rule of English constitutional law is incorporated in our constitution. The Indian constitution envisages a parliamentary and responsible form of government at the center and in the states, and not a presidential form of government. The powers of the governor as the constitutional head are not different. My lord, these paras are quoted. What, my lord, your lordships have, my lord Justice Suryakant has the right copy, my lord, I believe.
It's supposed to be.
I thought so, my lord. It, my lord, volume Roman 5, 29.
From Allahabad, there's nothing there. 11,670 पेज खोलिए.
My lord, can I give my copy for immediate reference? My lord?
यानी मिल गए.
State of Punjab versus governor.
Well, yes, go to.
My lord, 11669,
Paragraph 16.
paragraph 16. My lord, I'm grateful. My lord, where
Shamsher Singh.
Shamsher Singh is noted, para 28 and 32 are quoted, my lord, which I read. May I reread it, my lords? Or may I my lord, read them again?
Yes.
Yes. Under the cabinet system of government as embodied in our constitution, the governor is the constitutional or formal head of the state, and he exercises all his powers and functions conferred on him by or under the constitution on aid and advice of his council of ministers, save in spheres where governor is required by or under the constitution to exercise his function in his discretion. It is a fundamental principle of English constitutional law that ministers must accept responsibility for every executive act. In England, the sovereign never acts on his own responsibility. The power of the sovereign is considered by the practical rule that the crown must find advisors to bear responsibility for his action. Those advisors must have confidence of the House of Commons. This rule of English constitutional law is incorporated in our constitution. The Indian constitution envisages a parliamentary and responsible form of government at the center and in the states, and not a presidential form of government. The powers of the governor as the constitutional head are not different. Well, these two paras are quoted. What is missed from Shamsher Singh is in my written submission at page 197. Well, these two paragraphs. Your lordships are at page.
Other than those two paragraphs, nothing else is referred of some shade thing.
And this is what I'm now showing.
54 and 55 you want to.
And it's a, Shamsher Singh is 7.
66.
Well, please see para 54 and 56. The provisions of the Constitution, your lordship gets one. The provisions of the Constitution which expressly require the governor to exercise his powers in his discretion are contained in articles to which reference has been made. To illustrate, Article 239(2) states that where a governor is appointed an administrator of an adjoining union territory, he shall exercise his functions as such administrator independently of his council of ministers. The other articles which speak of discretion of the governor are para so-and-so, so-and-so, 6th schedule, and article so-and-so, so-and-so. The discretion conferred on the governor means that as the constitutional or formal head of the state, the power is vested in him. In this connection, reference may be made to Article 356, which states that the governor can send a report to the president that a situation has arisen in which the government of the state cannot be carried on in accordance with provisions of the Constitution. Again, Article 200 requires the governor to reserve for consideration any bill which, in his opinion, if it became law, would so derogate from the powers of the High Court as to endanger the position which the High Court is designed to fulfill under the Constitution. Now, 55. In making a report under Article 356, the governor will be justified in exercising his discretion, even against the aid and advice of the Council of Ministers. The reason is that the failure of constitutional machinery may be because of the conduct of the Council of Ministers. This discretionary power is given to the governor to enable him to report to the president, who, however, must act on the aid and advice of Council of Ministers of the center in all matters. In this context, Article 163(2) is explicable that the decision of the governor in his discretion shall be final and the validity shall not be called in question. The action taken by the president on such a report is a different matter. The president acts on aid and advice of Council of Ministers. In other matters where the governor acts in his discretion, he will act in harmony with his Council of Ministers. The Constitution does not aim at providing a parallel administration within the state by allowing the governor to go against the advice of Council of Ministers. Now, please see 56 is important. Similarly, Article 200 indicates another instance where the governor may act irrespective of any advice from the Council of Ministers. In such matters where the governor is to exercise his discretion, he must discharge his duties to the best of his judgment. The governor is required to pursue such course which are not detrimental to the state. Lord, now I'll come to that, my lord, and my learned friend also will take assist your lordships on that. Lord, in the judgment of Tamil Nadu, this is distinguished by the Honorable two-judge bench, my lord, relying upon a concurring opinion in this 7-judge bench judgment, my lord. One paragraph of the concurring judgment, I'll come to that. Now, my lord, next judgment is MP Special Police Establishment Act. Again, my lord, 5 judges, and was not noticed by the state of Punjab judgment. Now, para 11, I'll skip, my lord, the first part. First part gives the facts. What were the facts of that case, my lord, which may not be relevant for the present, but I have put it, my lord, for ready reference. Para 11. Mr. Sorabji submits that even though normally the governor acts on the aid and advice of Council of Ministers, but there can be cases where the governor is, by or under the Constitution, required to exercise his functions or any of them in his discretion. The Constitution of India expressly provides for contingencies, my lord, so and so, so and so, so and so. However, merely because the Constitution of India expressly provides, in some cases, for the governor to act in his discretion, can it be inferred that the governor can so act only where the Constitution expressly so provides? If that were so, then subclause 2 of Article 163 would be redundant. A question whether a matter is or is not a matter in which the governor is required to act in his discretion can only arise in cases where the Constitution has not expressly provided that the governor can act in his discretion. Such a question cannot arise in respect of matters where Constitution expressly provides that the governor is to act in his discretion. Article 163(2) therefore postulates that there can be matters where the governor can act in his discretion even though the Constitution has not expressly so provided. Mr. Sorabji relies on the Samsher Singh versus State of Punjab. A 7-judge bench of this court inter alia considered whether the governor could act by personally applying his mind and or whether under all circumstances he must act only on the aid and advice of councillors, ministers. It was inter alia held as follows. My lord, para 54 to 56.
Which you just read.
Which I just read, which, my lord, appears to have escaped the attention of the bench in State of Punjab. Now, my lord, again, MP judgment again starts. Thus, as rightly pointed out by Mr. Sorabji, a 7-judge bench of this court has already held that the normal rule is that the governor acts on the aid and advice of Council of Ministers and not independently or contrary to it. But there are exceptions under which the governor can act in his own discretion. Some of the exceptions are as set out here in above. It is, however, clarified that the exceptions mentioned in the judgment are not exhaustive. It is also recognized that the concept of governor acting in his discretion or exercising independent judgment is not alien to the Constitution. It is recognized that there may be situations where, by reason of peril to democracy or democratic principles, an action may be compelled which from its very nature not amenable to ministerial advice. Such a situation may be where bias is inherent and or manifest in the advice of the Council of Ministers. My lord, this judgment of MP, 5-judge bench, my lord, is, my lord, not considered, my lord. It has escaped the attention. Now I come to, my lord, most important judgment, Nabam Rebia, a relatively recent judgment, my lord, Arunachal Pradesh, my lord, issue. Lord, I must say, this is again, my lord, not, my lord, it has escaped the attention of the bench in State of Punjab. It was placed for consideration in Tamil Nadu judgment, my lord, but it quotes some paragraphs, Tamil Nadu judgment, but para which I am going to read, my lord, again has missed the attention of the bench, my lord. Kindly see, my lord. Similarly, in Nabam Rebia, para 151, 152, the Honorable Court referred to the Punchi Commission's formulation that governor's discretionary powers include to give assent or withhold or refer a bill for presidential assent under Article 200 and expressly endorse and adopt it. It was held as under. But 151, the important observation in Justice M.M. Punchi Commission report with reference to Article 163(2) are contained in para 4.5. The relevant extract in the extract of the same is as under. Article 163(2) gives an impression that the governor has a wide, undefined area of discretionary powers even outside situations where the Constitution has expressly provided for it. Such an impression needs to be dispelled. The Commission is of the view that the scope of discretionary powers under Article 163(2) has to be narrowly construed, effectively dispelling the apprehension, if any, that the so-called discretionary powers extends to all the functions that the governor is empowered under the Constitution. Article 163 does not give the governor a general discretionary power to act against or without the advice of his Council of Ministers. In fact, the area for exercise of discretion is limited, and even in his limited area, his choice of action should not appear to be arbitrary or fanciful. It must be a choice dictated by reason, activated by good faith, and tempered by caution. The governor's discretionary power are the following: to give assent, this is Punchi Commission. The governor's discretionary powers are the following: to give assent or withhold or refer a bill for presidential assent under Article 200, the appointment of chief minister under Article 164, dismissal of government which has lost confidence but refuses to quit since the so-and-so, so-and-so, so-and-so. Now, my lord, Nabam Rebia, 5-judge bench again, my lord, quotes with approval this observations and says, we are of the considered view that the inferences drawn in the judgment MC Punchi Commission report extracted herein above are in consonance with the scheme of the functions and powers assigned to the governor with reference to the executive and legislative functioning of the state, and more particularly with reference to the interpretation of Article 163. We endorse and adopt the same as a correct expression of constitutional interpretation with reference to the issue under consideration. My lord, if your lordships were to see, my lord, how this is dealt with in Tamil Nadu, volume 31, my lords. This is 151, 152. Lord, this Nabam Rebia is missed in Punjab judgment. Tamil Nadu judgment takes note of it. But please see, my lord, so far as these two paragraphs are concerned, my lord, that again has missed the attention of the bench, my lord, in Tamil Nadu, my lords. My lord, page 12432, para 301. Lordship gets, my lord. 11301. Lord, another constitution bench of this court in Nabam Rebia had the occasion, my lord. Thereafter, the
One page number?
I'm sorry, 12432.
Yes. Paragraph
12432.
Yes.
Para 301. Another constitution bench of this court in Nabam Rebia. Nabam Rebia is, my lord, taken note of. Then, my lord, the honorable court is pleased to quote 140, para 147.1, 147.2, 148, 149, and at page 12435, Lord, possibly misses 151 and 152, which I read, and comes to 154. And this discussion in Tamil Nadu is directly while dealing with the question of discretion. These two paragraphs, my lord, since, my lord, it escaped the attention of the two-judge bench, my lord, I am placing for your lordship's consideration. Now, my lord, I come to the next judgment, that is B.K. Pavitra. But this is two-judge bench judgment, which is declared.
Just 1 minute. Come back to page 12432. The Tamil Nadu judgment refers to paragraphs 147, 148, 149, and then it jumps to paragraph 154. 151 and 152 are left out.
That's what I submitted, my lord, with profound respect. That two paragraphs seems to have escaped the attention of the bench, my lord. Because from 149, it directly goes to 154. And in my submission, the real law is laid down in 151 and 152. And this is, my lord, while discussing discretion, the point which I am arguing, my lord, whether in all cases aid and advice is binding or there is a room for discretion. Lord, now please come to page 200 of my submissions, my lord. B.K. Pavitra judgment. Lord, this issue was squarely there.
Can you
This-
read the 154 with Tamil Nadu refers to? Underline,
Only a minute.
which comes after 152. They same very page. 154 of Tamil Nadu follows 151 and 152.
Please maintain that though.
Oh,
the
Lord,
paragraphs are
154 is Nabam.
Both are missing.
paragraph.
151 and 150.
Lord, 154 is slightly different from 151, 150. It is not slightly, but not substantially. Lord, now kindly come to B.K. Pavitra. Page 200. This is, of course, a two-judge bench judgment, but it is declared per incurium. And I'm not repeating the argument, my lord, but this itself was sufficient enough for a reference under 145.3. Lord, apropos your lordship's very correct, my lord, the proposition, my lord, the Chief Justice says at the outset that in every matter we are not supposed to look at 145.3.
But
at the
as far as justiciability is concerned, paragraph 155.5, Ebam Revia.
Yes, ma'am. But 155 will have to be read in context of 151,
Yes,
150.
but then even you read 155.5.
Fifthly, the underlined portion, highlighted part. Fifthly, the submission advanced on behalf of the respondents that the exercise of discretion under Article 162 is final and beyond the scope of judicial review cannot be accepted. Firstly, because we have rejected the submission, but this is on judicial review, not on discretion. Rejected advance by the respondent that the scope and extent of discretion vested with the governor has to be ascertained from Article 163(2) on the basis whereof the submission was canvassed. And secondly, any discretion exercise beyond the governor's jurisdictional authority would certainly be subject to judicial review. It was on judicial review. And it is, if it is beyond, but not obviously, but if governor.
According to you, under 200, he has an ample discretion.
That's
And
what
therefore-
Nabam Rebia says, my lord. And my lord, that's my contention. He has ample discretion, my lord. Situations may differ. The instances which are given in all the judgments are illustrative, not exhaustive. But they say that it is wrong to say that in every matter, like precedent, he is bound in every matter by aid and advice of the Council of Ministers. Samshay Singh also, my lord, 7-judge bench says that there are discretionary areas, including Article 200. Specifically, Article 200, every constitution bench mentions. That was precisely, my lord, the question in Tamil Nadu. I'm not, my lord, deviating from this point, but, my lord, just to, my lord, kind of respectfully respond, my lords have very rightly said that in every case, it's not necessary that the court would examine 145.3. A bail petition comes, it would involve Article 21, but it won't become a constitutional interpretation question that it has to be referred to the larger bench. But this was a case where only issue was constitutional interpretation. Facts were not, my lord, much in dispute. Anyway, my lord, leave it at that. Please come to B.K. Pavitra. Para 66. This is, my lord, declared to be per incurium by the two-judge bench, my lord, in Tamil Nadu. I'll show, my lord, that. Where a bill is not a money bill, your lordship gets. Where a bill is not a money bill, the governor may return the bill for reconsideration, upon which the House or Houses, as the case may be, will reconsider the desirability of introducing the amendments which the governor has recommended. If the bill is passed again by the House or Houses, as the case may be, the governor cannot thereafter withhold assent. The second proviso to Article 200 stipulates that the governor must not assent to the bill but necessarily reserve it for the consideration of the President if the bill, upon being enacted, would derogate from the powers of the High Court in a manner that endangers its position under the Constitution. Save and except for bills falling within the description contained in the second proviso, where the governor must reserve the bill for consideration of the President, a discretion is conferred upon the governor to follow one of the courses of action enunciated in substantive part of Article 200. Aside from bills which are covered by the second proviso, where the governor is obliged to reserve the bill for consideration of the President, the substantive part of Article 200 does not indicate specifically the circumstances in which the governor may reserve a bill for consideration of the President. The Constitution has entrusted this discretion to the governor. The nature and scope of the discretionary power of the governor to act independent of or contrary to aid and advice of Council of Ministers under Article 163 was discussed in Nabam Rebia versus so-and-so, where my lord 154 is quoted. My lord, I've read, I'll skip that. Then para 67 of BK Pavitra. The framers carefully eschewed defining the circumstances in which the governor may reserve a bill for a consideration of the President. They did not give instances, they left it open-ended. By its very nature, the conferment of power cannot be confined to specific categories. Exigencies may arise in the working of the Constitution which justify a recourse to the power of reserving a bill for the consideration of the President. They cannot be foreseen with the vision of a soothsayer. The power having been conferred upon a constitutional functionary, it is conditioned by the expectation that it would be exercised upon careful reflection and for resolving legitimate concerns in regard to the validity of the legislation. The entrustment of a constitutional discretion to the governor is premised on the trust that the exercise of authority would be governed by constitutional statesmanship. In a federal structure, the conferment of this constitutional discretion is not intended to thwart democratic federalism. The state legislatures represent the popular will to those who elect their representatives. They are the collective embodiment of the will. The act of reserving a bill for assent of the President must be undertaken upon careful reflection, upon a doubt being entertained by the governor about the constitutional legitimacy of the bill which has been passed. Article 200 contains the source of the constitutional power which is conferred upon the governor to reserve a bill for consideration of the President. Article 254(2) is an illustration of the constitutional authority of the governor to My Lord Justice Suryakant has the same 5 minutes. Article 200 contains the source of the constitutional power which is conferred upon the governor to reserve a bill for consideration of the President. Article 254(2) is an illustration of the constitutional authority of the governor to reserve a law enacted by the state legislature for consideration of the President in a specified situation where it is repugnant to an existing law or to a parliamentary legislation on a matter falling in the concurrent list. Eventually, which is specified in Article 254(2), does not exhaust the ambit of the power entrusted to the governor under Article 200 to reserve a bill for consideration of the President. Apart from repugnancy in matters falling in the concurrent list between state and the parliamentary legislation, a governor may have sound constitutional reasons to reserve a bill for consideration of the President, apart from the repugnancy issue. Article 200 in its second proviso mandates that a bill which derogates from the powers of the High Court must be reserved for consideration of the President. Apart from bills which fall within the description set out in the second proviso, the governor may legitimately refer a bill for consideration of the President upon entertaining a legitimate doubt about the validity of the laws. By its very nature, it would not be possible for this court to reflect upon the situations in which the power under Article 200 can be exercised. This was noticed in the judgment of this court in Hext, so and so. Lord, I'm sorry, I'm always confused with this pronunciation. Excluding it from judicial scrutiny, the court withheld. My Lord, I have read this, my Lord, when I read haste, my Lord, so I'll not. Uh, hmm? Yes, my Lord. But I'm not reading it, my Lord. Now, your Lordship, my Lord, kindly come to, my Lord, this point is over, my Lord. My Lord, there are some issues, my Lord, which we have divided with a view to save time, my Lord. My learned friend also would assist your Lordships, would supplement without, my Lord, repeating, my Lord. They would be able to more and effectively assist your Lordships. My Lord, kindly come to 204. But,
In a louder manner.
yes, sir.
Both of them.
It survives.
No, anything remains, no, not survives.
Survives for you.
Yes, sir.
We'll have to put off the wife.
Yeah, yeah. There was an interesting incident. I'll not share it here. My Lord Justice Narasimha, me and my colleague, my Lord, we went to Pune for arguing one matter, my Lord. Before NGT Pune, my Lord. But I'll some other day, not in the matter. My Lord, question number, page 204.
Why are you unnecessarily telling about anxiety?
No.
Either you should have not mentioned,
Now we have
or
mentioned
if you have mentioned,
yes.
you should mention it fully.
Yes.
Unless it is not embarrassing to my learned brother.
No, but it's not, my Lord, embarrassing to his.
So what happened in NGT Pune?
Lord, I'll just say with his permission.
Not let you proceed without-
No, I'll say that.
You
with
can't,
his-
you can't
play.
stop halfway.
Lord, I'll say that with permission of my learned friend and with an apology. It's not intended to insult. Lord, NGT Pune is a small courtroom. It's like a little slightly bigger bedroom. It's in a government building. My learned friend, all of us were on the same side. He was arguing, Lord, in his own way. Justice Kingaonkar.
In his own volume.
Yes. Justice Kingaonkar was presiding over the bench.
Yes.
So at some stage, he did like this. So my learned friend understood that the honorable judge is unable to cope up with my speed. So he continued the same volume. But reduced the speed. Then I requested my learned friend that the trouble is with the volume, not the speed. And the judge complimented me by saying that, thank you, you prevented Punjab Mail. Sorry, but he's like my brother, my Lord. I can take this liberty. My Lord, page 204. Lord, this is, my Lord, something very, very serious, and your Lordships may take this, Lord, into consideration. One constitutional organ prescribing time limits for another constitutional organ. Lord, I can, my Lord, I have no quarrel and I will never argue, my Lord, and I'll pitch my argument that statutory functionaries can be bound by a time limit. The deputy collector deciding to grant or withhold non-agricultural permission. But would it apply to constitutional functionaries which are coordinate constitutional functionaries? My Lord, these are the two questions, my Lord, which are question number 5 and question number 7. My Lord, I have incorporated, my Lord, the debate which I have already read. In one line, I may just refresh your Lordship's memory. Wherever time limit was stipulated at the time of drafting of the Constitution, the time limit was deleted. And in that very provision, wherever time limit was required, time limit is added. So constitutional framers are very conscious of the fact that some functions need a time-bound exercise of power and some functions needs a kind of leeway, and we may not bind the constitutional functionaries with the power. My Lord, please come to page 208, and I'm not going to read this, only for your lordship's assistance at page 209. My lord, I have compiled the constitutional provisions where constitution itself stipulates the time limit. I'm not reading it, my lord, just my lord, with a view to see that your lordships gets it, my lord, at one place. My lord, 209, Article 22, Article 62, etc., my lord, the list goes on till at page 224. Wherever the Constitution has thought it appropriate for the object which that particular provision seeks to achieve, the Constitution provides for a time limit. Wherever the Constitution has, framers have considered. Yes, my lord, kindly note one more thing. Tamil Nadu judgment, which mandatorily stipulate time limits for the Honorable President and the Honorable Governor, relies upon the report of Punchi Commission and Sarkaria Commission. It itself says at the end, and obviously so, that these are our recommendations and we recommend suitable constitutional amendments. Meaning thereby, the reliance on the report itself, my lord, in my respectful submission, may not be correct, because Commission does not say that do it by way of a judicial adjudication. It has to be, my lord, logically, I don't have to stretch this point any further. If a commission is appointed by the central government of the day will consider whether to bring it by way of an amendment or not. But very interestingly, my lord, a converse situation has arisen. My lord, in one judgment, which your lordships would find at page 231, where one organ of the state, namely the legislature, provided for the time limit for another organ of the state, namely the judiciary. And matter went before, my lord, 7 judges bench. And your lordships would find the judgment at page 231.
238.
231.
Paragraph 230.
Lord, I'm sorry, my lord. One fact, my lord, I missed. Lord, there are judgments which I have cited from page 224 to 231 that even in statutes, court cannot add words, supplement words, or delete words. Lord, the leading
Except
judgment.
causes omissus.
Yes, ma'am. It is conscious omission. And even if the court were to do it, court can suggest that we recommend or we suggest that the competent legislature may exercise its amending power, either constitutional provision or so. But, my lord, one judgment, which is, I'm not reading, page 228. 228 is the judgment, Lord, where my lord Justice Narasimha was also, my lord, on the bench. Suprio versus Union of India. Lord, this is a 5-judge bench, but I found, my lord, that it is not reportable. It has not been reported anywhere, my lords. So this was that right of LGBT community, my lord, my lord, seeking, where, my lord, the court said that we cannot read words into the statute. My lord, this judgment remains unreported. Thereafter, there are 2 judgments which relies upon this judgment, and those 2 judgments, my lord, including electoral bond, they are reported. But this judgment, my lord, remains unreported. As a matter of fact, that's all. Otherwise, my lord, it's a leading landmark judgment, my lord, laying down several issues of seminal constitutional importance, my lord, not only for the country, but for the society. I leave it at that. My lord, page 231. Page 231, my lord. When, my lord, Legislature, my lord, provided for timeline for the judiciary. This is where, my lord, we say the separation of powers, constitutional committee between or amongst three or coordinate organs of the state. In P. Ramchandra Rao versus State of Karnataka, Lord, that is 7 judges, has been held that time limits for criminal trials cannot be prescribed. Lord, your lordships would see, sometimes facts may justify time limit, but justification does not confer jurisdiction. We may come across a situation where we feel that it is fully justified, that some time limit should be done. But if there is no jurisdiction, there is no jurisdiction. Justification can never confer jurisdiction. Now, let's see, kindly see, my lord, what the 7-judge bench is pleased to observe when one organ fixes time limit for the other. My lord, incidentally here, it's a converse. Legislature fixing it for the judiciary. Para 225, my lord, of this judgment I have quoted. During the course of its judgment, also the Constitution bench made certain observations which need to be extracted and reproduced. But then speedy trial or other expressions conveying the said concept are necessarily relative in nature. Kindly pause here for a minute. There are several considerations: lack of staff, lack of my lord, the burden of cases,
Depending
several
upon the case.
considerations.
Depending on case to case, like.
Case to case, some case may take longer, some
Bomb
case
blast case, there might be 200, 300 witnesses.
witnesses. Lord, that is the justification. Lord, why I am pausing here? Lord, in case of decisions of the nature which governor or the president takes, they are polycentric decisions. They are not ticking the boxes that yes, complied with, complied with, complied with. There are they may decide, they may choose to call the governor, choose to call the chief minister. They may take some other consultative process to ensure that there is no impasse, etc., etc. And therefore, there may be several reasons for the delay. One may ask, speedy means how speedy? How long a delay is too long? We do not think it's possible to lay down any time schedule for conclusion of criminal proceedings. The nature of offense, the number of accused, the number of witnesses, the workload in the particular court, means of communication, and several other circumstances have to be kept in mind. It is neither advisable nor feasible to draw or prescribe an outer time limit for conclusion of all criminal proceedings. It is not necessary to do so for effectuating the right to speedy trial. We are also not satisfied that without such an outer limit, the right becomes illusory. Even apart from Article 21, courts in this country have been cognizant of undue delay in criminal matters, and whenever there were inordinate delay or whether proceedings were pending, where the proceedings were pending for too long and any further proceedings were deemed to be oppressive and unwarranted, they were put an end by making appropriate orders, prescribing periods of limitation at the end of which the trial would be obliged to terminate the proceedings and necessarily acquit or discharge the accused, and further making such directions applicable to all the cases in the present and for future amounts to legislation which in our opinion cannot be done by judicial directives and within the arena of judicial lawmaking power available to the constitutional courts, however liberally we may interpret Article 32, 21, 141 and 142 of the Constitution. The dividing line is fine but perceptible. Courts can declare the law, they can interpret the law, they can remove obvious lacunae and fill the gaps, but they cannot entrench upon the field of legislation properly meant for legislature. Binding decisions can be issued for enforcing the law, and appropriate directions may issue, including laying down of timelines or chalking out a calendar for proceedings to follow to redeem the injustice done or for taking care of rights violated in a given case or set of cases depending on facts brought to the notice of the court. Now, my lord, this court says this, my lord, which generally it reserves its own my lord, domain. This is permissible for the judiciary to do. Legislature cannot. But it may not, like the legislature, enact a provision akin to or on the lines of chapter so-and-so of the Code of Criminal Procedure. So legislature cannot. My lord, here also, I think, my lord, the provision was deemed acquittal or something. Deemed. My lord, it was judgment of the Supreme Court which put time limits
Right.
on completion of the trials, and the
Many benches.
my lord, recently in Allahabad High Court, my lord, judgment also, my lord, where the my lord, that Asian resurfacing judgment that it will have to be decided within 6 months or interim order will be deemed to have been vacated.
That is reviewed.
Yes.
That is recalled.
That's recalled by a 5-judge bench. 5-judge bench. Lord, here the judgment said judiciary's power is untrammeled, Lord, as per all the judgments, that if it is not decided within 6 months, the interim order is deemed to have been vacated. We are also dealing with, my lord, similar situation where it is deemed assent, etc. My lord, I'll come to that.
Outer limit at all. Real question is, isn't there an outer limit? Can the constitutional interpretation be left to a vacuum, creation of a vacuum, a long jump?
My lord, there are two answers.
Jump by, of course, we have had that there's nothing like a pocket veto. Just keep it and don't respond. That's not permissible. But though we can't specify a time limit. But at the same time, there must be some way in which the process works out. Can it be a situation where not acting on a bill which is sent to the governor
My lord, that is,
itself is a full stop, no further, is it?
my lord, I'll answer it.
Where we need your assistance.
Yes, my lord. I'll answer, my lord, in two ways. A, what your lordships very rightly, my lord, feels pained at is a justification for fixing time limit, but will not confer jurisdiction to fix time limits. Number two, if that is so, Lord, we are not flooded with cases where, my lord, such situations have arisen. Lord, there are instances where, Lord, 1 or 2 states have come, my lord, with such situations. If that is the problem, and that may be the problem, the remedy lies with the constitutional framers, my lord, with the parliament. The parliament will have to be done. Your lordships have said time and again in several judgments that in view of this, we request the parliament. Your lordships never direct. Your lordships never direct, coordinate constitutional functionary. Even if the notice goes to a constitutional functionary, your lordships registry's form is also different. You are called upon to remain present is not there. You are requested to put your appearance because that's the constitutional committee. Lord, your lordships have said in large number of cases that the desirability of the parliament to consider this. But the practical answer, my lord, if I were to, my lord, assist your lordships, is the political answer. Suppose a particular governor is, my lord, sitting over the bill, my lord, there are political solutions. And such solutions are taking place, and my lord, it is not everywhere that state is advised to rush to the Supreme Court. Lord, the chief minister goes and requests the prime minister. Chief minister goes and meets the president. There are delegations which go that this is the bill which is pending. Please talk to the governor. Let him take decision one way or the other. Telephonically, they are sorted out. There is a joint meeting with prime minister, chief minister, and the governor, or the president, chief minister, and the governor. And such impasse is not solved. Lord, that would not confer jurisdiction to lay down a guideline by a judgment. That is the question. That in absence of a constitutionally provided guideline, time limit, can it be read even if there is a justification? And my lord, genuinely, my lord, I'm urging your lordships to consider such issues are arising in every state since last many decades. I'm not talking of this government or that government, but the statesmanship, the political maturity, the political statesmanship, they are at play. They meet the constitutional functionaries at the center. They discuss, debate, because all bills are not contentious bills. They are kept, my lord, for one reason or the other. There is some impasse, some lack of communication. Some clarification might be required, which might be wanting. Then, my lord, they come together and a political solution is found that, all right, if you don't want to do it, refer it to the president will examine. Lord, these are the solutions of the problem. Lord, I'm therefore, my lord, at the cost of making a little unpleasant argument, my lord, saying that every problem in this country may not have solutions, my lord, here. There are problems, my lord, in the country where you must find solutions within the system. This is what your lordships have said in this judgment, that there is a question of delay. Article 21 is affected. People are languishing in jail. But solution will have to be found from within the system. And your lordships are doing a lot from within the system for streamlining, for ensuring that timely trials take place with assistance of the legislature. Now we have, my lord, the legislative provisions that even summons can be served through electronic mode. Even a WhatsApp message is a good service of summons. How responsibilities are fixed for the officers to bring in witnesses, etc. But this is a collaborative exercise. Lord, suppose, my lord, there is a bill passed by the parliament. Kindly, my lord, suppose there is a bill passed by the parliament that people of the country are approaching us that my trial is pending since 30 years, my son is in jail, and it is not being taken up. I'm posing a question to myself, my lord, can the executive, maybe the president of India, say that, no, I understand there is a problem, and therefore your trial is treated to have been terminated. You are deemed to have been acquitted. You have already undergone 30 years. It cannot be done. Justification can never confer jurisdiction. And this separation of power, what I am saying without mincing words, must be a two-way street. Lord, I'll just show your lordships Allahabad judgment, where there was again a judicial verdict, where within 6 weeks, if it is not done, 6 months, then it is vacated. Then, my lord, this court, my lord, speaking through 5 judges bench, set aside that no time limit can be prescribed. Now, please come to another judgment, which is again a landmark judgment, my lord.
Mr. Solicitor, that against the inaction of the governor in a particular given period. It can vary from state to state, it can vary from action to action, or inaction to inaction.
My apologies.
In a particular case of inaction, if the aggrieved state or its functionaries, if they approach the court, the power of judicial review according to you is completely barred.
Look, right now, I am on the point, I am not on justiciability or judicial review. I am on the point that by a judgment, the court cannot fix time limit. That you do it within 3 months.
All right, you will expand this argument and then will also enlighten then what kind of the
Remedies available to
remedy
the
the
person.
courts would.
Therefore, my lord, I answered.
If there is a wrong, then there has to be a remedy.
Ubi just ibi remedium, my lord, I understand. But there are, my lord, problems which all problems in the country may not be this forum to be the only solution.
Okay.
There are solutions, my lord, within the system, and people are finding out those solutions.
No, as the custodians of the Constitution, this court is a custodian of the Constitution.
My lord, each organ is, my lord. Each organ is in their own respective fields, my lord.
Suppose if a constitutional functionary, which is entrusted with certain functions, refuses to discharge those functions without any valid reasons, Whether the courts, the hands of the constitutional court would be tied and say that, no, we are powerless.
It's not, my lord, an
Power of
argument of,
interpretation only the Supreme Court has of the
My lord,
Constitution.
my lord, that is the feeling, my lord, that all problems.
Interpretation of the Constitution.
Interpretation, yes. Yes, yes, yes.
Court has.
Interpretation, yes, my lord, but not legislation.
No,
Then now
not
there is a problem, you do it in 3 months. Okay, kindly see, my lord, the way, my lord, it,
For that, cannot we go to the constitutional debates? Find out what was the intention of the Constituent Assembly behind enacting such provisions. If we do that,
no, no, your lordships can consider, my lord, whichever way, my lord. My argument is this, my lord, that time limit cannot be stipulated.
If the power of interpretation of the Constitution, if the power of interpretation of the Constitution rests in the Supreme Court, then rules of interpretation of law are to be tried by the court.
My lord, then, my lord, my answer is one answer. Justiciability is something else. Adding words or amending the constitution itself, your lordships have said even statute cannot be amended by judgment, is something else. Generally, and this is my answer, my lord,
we have to go on the first principle, literal interpretation.
basically, my lord, what a tap on the back jurisdiction, my lord, as we understand, you can always say that just look into it. You can call the law officer, just look into it and see that it is done, and it is generally done, my lord. But please see, my lord, the directions. My lord, I would respectfully urge your lordships to see that.
We agree. But if extreme view is taken, is no justification to argue that you can't therefore take any view at all. We are not at the two extremes of prescribing time limits now here within 1 week or so, or on the alternative, don't have a power at all to do it.
My lord,
There must
I'm
be a
coming,
way by which you make the constitution work,
my lord,
process work.
flexibility has to be there. The system must work smoothly.
No, there is no doubt that you must have free play in the joints.
My lord, kindly see the
But,
direction for my satisfaction.
Yes, that is,
My lord, page 12569, volume 31, volume 31, my lord, Roman 531.
they begin at 12569.
No, no, the relevant part, the directions, my lord, where in our submission, my lord, this amounts to amending the para, my lord, is Roman 14 of the conclusions.
Yes.
These are, I'm reading the conclusions.
12569 to 1259.
12569. Your lordships have, my lord, it starts with timelines. My lord, kindly come to 12568 first. What is this, my lord? Your lordships would, and with profound respect, my lord, every judgment deserves the respect, my lord, and maybe there may be a justification for doing this, but my argument is justification do not confer jurisdiction. My lord, 14, keeping in mind the constitutional significance. Your lordship gets, my lord?
Yes, yes.
My lord Justice Narasimha gets. Keeping in mind the constitutional significance of Article 200 and the role it plays in the federal polity of the country, the following timelines are being prescribed. Failure to comply with these timelines would make the inaction of the governor subject to judicial review by the courts. In case of either withholding of assent or reservation of the bill for consideration of the president, upon aid and advice of the State Council of Ministers, the governor is expected to take such action forthwith, subject to a maximum period of 1 month. In case of withholding of assent contrary to the advice,
In case of either withholding of assent or reservation of the bill for consideration of the president upon the aid and advice of the president,
then 1 month.
the government is expected to take such action forthwith. What action?
Either withholding, assenting, or reserving, etc. But the governor may choose that I'll call the chief minister, we will have debate, discussions, persuasions. What is the problem I am facing? You are, if you can again go back to your cabinet and sort out the situation, nothing. Then, my lord, 2, in case of withholding of assent, contrary to the advice of the State Council of Ministers, the governor must return the bill together with a message within a maximum period of 3 months. In a case of reservation of bills for the consideration of the president, contrary to the advice of the State Council of Ministers, the governor shall make such reservation within a maximum period of 3 months. In case of presentation of a bill after reconsideration in accordance with the first proviso, the governor must grant assent forthwith, subject to a maximum period of 1 month. Lord, this, my lord, is, and my lord, thereafter the says that a president will, my lord, there are 2 things. And my lord, I'll try to be as modest as possible in placing this. And I'll come to that, my lords. It's a separate chapter, but let me at this stage say, the second direction given is, my lord, that president and governor will record reasons. And if they do not follow these guidelines, this timeline, states can come to the High Court, go to the High Court or come to us. Meaning thereby, this honorable court, one institution of the 3 coordinate branches, is directing the Honorable President of India that you decide within 3 months, you better give reasons, and you, the state, if she doesn't decide, file a petition in 226 or come here under 32. This is, my lord, the direction. I respect the directions, my lord. There may be justification, but justification cannot confer jurisdiction.
Clear cutoffs, the cutoffs.
Have amended the constitution.
No, this, Pavitra is in ignorance of Samsher Singh.
No, Tamil Nadu judgment.
No,
No, Pavitra
according
is
to Tamil
handling
Nadu
that.
judgment, Pavitra, which says that there
It's per
can't be
incurium.
per incurium Samsher Singh.
No, yes, which it is not. My lord, I'll show that paragraph.
Para 56.
We're just wondering because it's 12:10, so whether the learned solicitor would be asking for a comfort break.
No, no. Yes. I am generally comfortable till 1 o'clock. That word is coined during Corona. Comfort break, my lord. That's a good word, my lord.
Even in the conferences now they use that word,
Yes.
comfort break for 15 minutes.
Sense of humor is always welcome in this court. The sense of humor is always welcome in this court.
Yes. Otherwise, my lord, the proceedings are generally boring,
Boring, monotonous.
monotonous, boring. The subject is also boring. And
The subject is
The subject is not boring. Yes.
not at all.
no, subjects means the law as a subject, not this subject. You need not oppose me everywhere. I'm not saying this subject is boring. Generally, law as a subject is not a very interesting subject, my
I
lord,
don't
for
agree at all. It's
others.
the most interesting subject, Malad.
My learned friend is
I have
H.P.
to be a
Kamath.
Kamath. I have to
He
be
is
a
Mr.
Kamath.
Kamath, my lord. He is Mr. Kamath, my lord. He opposes everything I say.
Hari Vishnu Kamath.
Yes. No, now on the timeline, no, there is a direct judgment of the 5-judge bench. Lord, kindly come to page 233.
230.
233.
Your notes.
Yes, my written submissions. 233. Article 200 was considered from the point of view of timeline. And timeline was not prescribed. Lordships may kindly keep one thing in mind. Article 200 follows with Article 201. Obviously, in Article 201, timeline is stipulated. If the President returns the bill to the Legislative Assembly within 6 months.
6 months.
Wherever, my lord, I have not read the list and I don't intend to, but all provisions where it was necessary that timeline has to be prescribed, it is so prescribed by the Constitution. The only question is, can it be done by a judgment even if there is a justification in a particular case? Maybe the court may be confronted with some extraordinary fact situation and feel that this is something extraordinary. Then the remedy will not again, my lord, be the judicial remedy. Now, please have a look at, my lord, page 233, 5-judge bench judgment of Purushottam Nambudri versus State of Kerala, para 15. This was a case where a bill would lapse because of non-prescription of the time limit, because one assembly may pass a bill, present it to the governor, and thereafter, my lord, the assembly's tenure is over. Or assembly resigns, new assembly is formed, etc. My lord, kindly see para 15. Your lordships have para 15. It is clear that if a bill pending the assent of the governor or the president is held to lapse on dissolution of the assembly, it is not unlikely that a fair number of bills which may have been passed by the assembly, say during the last 6 months of its existence, may be exposed to the risk of lapse consequent on the dissolution of the assembly, unless assent is either withheld or granted before the date of the dissolution. If we look at the relevant provisions of Article 200 and 201 from this point of view, it would be significant that neither article provides for a time limit within which the governor or the president should come to a decision on the bill referred to him for his assent. Where it appeared necessary and expedient to prescribe a time limit, the Constitution has made appropriate provisions in that behalf. Vide article so-and-so, so-and-so, so-and-so. My lord, the court cites only 3 examples, but in my list, I have given at least 30 examples.
More than 2 dozen, yes.
Where time is prescribed, wherever it is so felt necessary. In fact, the proviso to Article 201 requires that the House to which the bill is remitted with a message from the President shall reconsider it accordingly within a period of 6 months from the date of receipt of such message. Therefore, the failure to make any provision as to the time within which the governor or the president should reach a decision may suggest that the constitutional makers knew that a bill which was pending the assent of the governor or the president did not stand the risk of lapse on the dissolution of the assembly. That is why no time limit was prescribed by Article 200 and 201. My Lord, kindly as you visualize a situation where the outgoing assembly passes a bill, places before the governor. The new government is formed, maybe of a different political party. The new council of ministers can give advice to the governor to withhold that bill, that it was passed by the earlier assembly. Now the new assembly is formed. We would like to have a debate on that. The outgoing cabinet also may say that now our tenure is over. You grant assent to the bill. Now, in view of the judgment, you have to do it within 1 month. The governor may choose that now this is outgoing ministry. Let me wait till the fresh election takes place. Maybe the fresh mandate of the electorate returns somebody else, and they will apply their mind. Outgoing people who have lost their time of electoral mandate may not impose their decision on the incoming. So, my Lord, these are all polycentric circumstances which governor, my Lord, as constitutional framers, my Lord, envisage as a friend, philosopher, guide, as a person who is there as a central representative to ensure that everything functions smoothly. There are several considerations which weigh.
Question in Purushottam Nambudiri, was it considering an issue of lapse of a bill?
It was a lapsing.
Was it considering delays?
Lapse.
That's a bill on the event of dissolution of the
It won't
assembly.
lapse. Therefore, they have answered the question that it won't lapse.
No, they've answered the question.
Correlative, but you are saying,
My Lord, fight.
considering that it won't lapse, one should assume.
But then these observations on a two-bench.
The five-judge bench observation, my Lord, that
The two judges ought to have considered this.
Lord,
Was it cited before that?
wherever, my Lord, it not only confines to the lapsing or not lapsing. It says that time limit cannot be prescribed for wherever it is necessary, it is so prescribed, and give examples. And whenever it is not prescribed, it is consciously not prescribed. Therefore, we cannot do it.
Was it cited before the learned?
Yes, my Lord, and it is dealt with at page para 235. I'll just, my Lord, show that.
Apply at all.
35 of you or the?
It says, my Lord, that it was in the context of lapsing.
Page number?
Para
Para
235,
235 of the judgment.
12379.
Huh?
My Lord, the learned judges, my Lord, is pleased to quote Nambudri
1, 2.
12379 at 12379.
Paragraph 236.
236.
232 से start हो गया. Yes.
Yes, my Lord. This para is quoted. It was cited, my Lord. And please, my Lord, bear in mind that Nambudri is a 5-judge bench.
This not. Yes, sir. Absolutely nothing to do with this matter.
So, para 236 may I read, my Lords.
Forget 236, read this judgment.
Lord, can I show, my Lord, the facts of Nambudri first, my Lord, if your Lordships would like to see. My Lord Justice Narasimha, my Lord, 1186 is the page number, my Lord, of volume 3. volume
5.3.
5.3 at page 1186. But even if the context was lapsing, what I read is the ratio.
Ratio.
Five judge bench says
That
that
wherever wherever the assembly required timelines to be provided,
they have
they
provided,
have provided,
and therefore we cannot provide for a timeline. The prayer was this, that you provide for a timeline, otherwise it would lapse.
Was pending before the president, and if this assembly would dissolve, it would last.
Yeah, they say wherever it is. I am reading, my lord, 1186, my lord, which is Nambudri, the facts of Nambudri.
Broadly stated.
356 order in this.
Lord,
Yes.
my lord, the Chief Justice says 1186, the facts of Nambudri. Just above 1186, my lord, para 2.
Starts from 1185, yes.
The
Right.
Kerala Agrarian Relations Bill.
Yes.
Lordship gets, my lord.
Yes.
The Kerala Agrarian Relations Bill, which has ultimately become the Act, was published in the Government Gazette of Kerala on December 18, 1957, and was introduced in Kerala Legislative Assembly on December 21, 1957, by the communist government, which was then in power. The bill was discussed in the Assembly and was ultimately passed by it on June 10, 1959. It was then reserved by the governor of the state for the assent of the president under Article 200 of the Constitution. Meanwhile, on July 31, 1959, within less than a month, more than a month, the president issued a proclamation under Article 356 and the assembly was dissolved. In February 1960, midterm general elections took place in Kerala, and as a result, a coalition government came into power. On July 27, 1960, the president for whose assent the bill was pending sent it back with his message requesting the Legislative Assembly to reconsider the bill in light of the specific amendments suggested by him. On August 2, 1960, the governor returned the bill remitted by the president with his message and the amendment suggested by him to the new assembly for consideration. On September 26, the amendment suggested by the president was taken up for consideration by the assembly, and ultimately on October 15, 1960, the bill as amended in light of the president's recommendation was passed by the assembly. It then received the assent of the president on January 21, 1961, and after this thus became law. This was the facts, and the issue was whether the bill would lapse or not, my lord. Now your lordships may kindly come to para 14. 1.4, my lord, which is at page 1193. Your lordship gets, my lord. 1193, my lord, gets, my lord. Para 14.
Yes.
In this connection, it is necessary to consider Article 200 and 201, which deal with bills reserved for the assent of the governor or the president. Article 200 provides inter alia that when a bill has been passed by the Legislative Assembly of a state, it shall be presented to the governor, and the governor shall declare either that he assents to the bill, or that he withholds assent therefrom, or that he reserves the bill for consideration of the president. The proviso, it's paraphrasing the proviso, my lord.
You had already read para 15 to us.
Para 15.
Either you or the learned attorney, either of you.
No, I read just now. I just now read, my lord.
Earlier it was.
Just now I read, my lord, that court said that no, we cannot read into any timeline. My lord, why the court is seeking 197(1)(b? Please have a look at 197(1)(b). This para 15 reads 197. Restriction on power of legislative council as to bills other than money bill, where there is a time limit stipulated. This question was considered. It is a ratio, not a passing reference. This is a statement of law. Lord, it's again paraphrasing.
They should read one
But Lord, it refers to 197. Para 14 and 15 both refers to 197, and 197 provides for a bill, for a time limit for a bill.
196.
So under 197, there are specific timelines.
Yes. And 200 does not have. Virtually, the prayer was that you read some timeline in 200.
And the argument was that the bill had lapsed.
Yes.
That was rejected.
Yes. Article 196, sub-article 5. And the Supreme Court says it doesn't lapse because there is no timeline. And whenever timeline was required, it is stipulated.
That was the question.
That's right.
So it is a statement of law. It's not a passing observation of a constitution bench. Well, that is why, my lord, the constitution bench gives the dates also. Time was the issue, my lord, that whether it should have been done within particular time limit. Now, my lord, again, my lord, B.K. Pavitra, I have read, my lord, I'll not repeat that, my lords. Now, my lord, the court Lord, relies upon 3 judgments, my lord, for fixing the time limit. I'm sorry, this Kesham judgment, my lord, that is the Manipur Assembly Speaker. I don't wish to, my lord.
No, Kesham, I have already distinguished.
Lord, it was a tribunal.
Because all the constitution benches have held that Speaker, while acting under para 6, acts as a tribunal and therefore is amenable to the jurisdiction of the High Court under Article 226, 227 and this code under 136. And while discharging those functions, it does not enjoy the constitutional immunity under 112 and 212.
Yeah, that Raja Rampal judgment 212, etc. will not apply because he is a tribunal. And therefore,
It's a tribunal, and right from Kyoto, it has been consistently held
yes,
that he doesn't enjoy the constitutional
immunity under the
Under-
privileges, etc.
112 is so by the Speaker and Chairman, and
212 for
so
assembly.
far as the state legislatures are concerned.
Yes. So it is, my lord, that can never be a justification for prescribing guideline for a constitutional functionary exercising.
Kesham also does not lay down guidelines in general.
It's only for 10th schedule.
No. It says in the facts of the case.
Yes, it doesn't bind other speakers.
Because an argument was made
It was paid.
like the UP case, the court itself should exercise the power and declare them to be disqualified because the disqualifier was apparent.
Mayawati judgment, my lord.
Mayawati, Raja
It was, my lord, Yadav, Rajendra Singh Rana.
Rajendra Singh Rana was
There, my lord, it was Mulayam Singh Yadav versus Mayawati. Court said that now 2 months have left.
from Mayawati's party, the 13 MLAs that defected to Mulayam Singh.
Mulayam Singh
They
Yadav.
had given a letter that Mulayam Singh should be made the chief minister.
Minister,
And-
that was
and-
treated.
And this court held that the very fact that the MLAs elected from BSP wrote a letter that
Other leader should be.
the leader of the SP should be made a chief minister. Itself was sufficient enough to disqualify them, and
On the ground that they
passed an order of disqualification directly in the Supreme
here.
Court.
And they said, but the Honorable Court said in Rajendra Singh Rana that they're writing a letter requesting the President to invite the other party's leader amounts to their voluntarily giving up membership of their original political party. Now 2 months of the assembly session has left, and therefore there is no point in returning the matter to the Speaker, and therefore we decide it here and declare them disqualified. But that is again, my lord, a Speaker is a tribunal, my lord, that In my respectful submission, my lord, I may not labor much. Lord,
Because that has been followed in Nebam Revia and
Nebam Revi, yes.
and Subhash Desai.
Yes.
Well, I've been making this argument for 5 years that it's a tribunal, Mullah, and every time the resistance was, but he's a speaker. Luckily, Mullah, we have your lordship's judgment, Mullah. But for 5 years, I've been saying that.
Constitution.
I know,
which
but
benches
Mullah,
also-
for 5 years, we've been saying because speakers are not deciding issues. And
And,
for years, they were not deciding. And I was saying they are tribunals, but for 5 years, Mullah, nobody accepted that position because the other side would say he's a speaker. Then your lordships decided the matter, and we are so happy that you did, Mullah. At least that put a quieter.
We have held that we don't want to create a situation of operation successful and patient dead. That we have said that we don't want to create a situation that operation successful and patient dead.
Lord, kindly come to page 238. Lord, interpretation of as soon as possible. My lord, your lordships have seen two things. In Article 200, main part, no time limit. Article 200 main part does not prescribe time limit. The proviso says as soon as possible. In this context, I'm just giving one judgment on as soon as possible. Please come to page 238. Lord, this was a case of preventive detention and therefore directly Article 21 was involved. Article 21 and Article 22, personal liberty, fundamental rights. Abdullah Kunhi versus Union of India. In Francis so-and-so,
Which page have you cited?
Lord, I'm sorry, 238. 238.
There are 253.
Yes, my lord, at the foot, para 14. In Francis Corel Mullin versus WC so-and-so, Justice Chinnappa Reddy, while dealing with the time imperative for consideration of representation, has emphasized, we, however, hasten to add that the time imperative can never be absolute or obsessive. The court's observations are not to be so understood. There has to be leeway depending on the necessities. We refrain from using the word circumstances of the case. One may well imagine a case where a detainee does not make a representation, then it is various situations concerning detainee. I have given the situations which the governor may say. Ultimately, my lord, the bold line, but allowance must surely be made for the necessary consultation where legal intricacies and factual ramifications are involved. Lord, here in this case, political considerations, politics not, my lord, in the derogative sense of the term, there can be, my lord, a political statesmanship which is at play. There may be a good reason for him to let the situation calm down. It might be, my lord, having some impact on the national policy. He might be in consultation with the President of India. There can be several. These are all polycentric decisions. These are not A versus B, whether A is right or B is right. It has consequences, it has fallouts, it has social implications, it has economic implications, it has implications outside the state. Lord, similar is the case, Lord, in Joglekar. I'm not reading it, it's the same, Lord, ratio. Then in 240, Lord, I'm not reading it, my Lord. Lord, the court's reliance on Sarkaria Commission and Justice Punchi Commission, Lord, is wrong because they also say that ultimately these are our recommendations, which the government which appointed them did not accept. But that apart, they also recommended that accordingly amend the constitution. They also did not even remotely suggest that the court can do that. Then, my lord, manner of exercise of power, my lord, which is at page 242. My lord, I'm not taking your lordship much time because I would earnestly request my learned senior friend, my lord, to deal with that. My lord, question is this, my lord. Can the manner of exercise of the power be prescribed by the court that you will give reasons? When there is a judgment, my lord, where there are some observations that some reasons are necessary. I'm not going into it because this is not a list. I'm just seeking the advice of your lordships whether a judgment can say that. My lord, I have, my lord, earmark page 245, para 272. I'll read only one para.
One minute.
But show us that portion of the two-judge bench judgment where reasons
Yeah,
are directed.
yes. This is Mr.
That may be valid for when some member of the executive exercises administrative powers,
Statutory powers, my lord, we can.
wherein some order inviting adverse civil consequences to a party is
Correct. My lord, for example, the deputy collector deciding whether to grant
license or not.
license, grant non-agricultural land use permission or not, etc., my lord. My lord, I don't think, my lord, we can reduce constitutional functionaries of coordinate benches, my lord, to this, my lord. I'll just find, my lord, show, my lord, the directions. Lordship, only give me a minute, no, we are just trying to find out. Yeah. No, my lord, I'll just, my lord, find out. We are unable to immediately lay our hands, but your lordships can take it.
There are directions that the
There are directions that
government should record it.
president and governor both would decide in a particular time frame. Second direction, both would give reasons. And third, in case of non-compliance, the state can approach the High Court and the Supreme Court. These are the three directions.
But the Contempt of Court Act.
No, my lord,
For
third.
seeking advice.
No, that is something, that is third.
But that will be in case of violation of timeline.
In case of violation of timelines, we can come for a mandamus that the High Court will direct the President of India that you have violated.
Issued why the fresh mandamus is required. Timeline
Now,
is
now,
General mandamus.
It may be a contempt action, my lord. There.
mandamus is issued, which is binding to everyone within the territory of India under 141.
It is 141. My lord, please come to page 245 of my my lord, submissions. Why, my lord? The nature of exercise, the manner of exercise of powers by coordinate constitutional functionaries. Lord, it may not be a good comparison, but suppose, my lord, the parliament or the executive were to say that courts should not give 600-page judgments. It's manner of exercise of power. Maybe they are just, maybe in some cases it may be required, but justification does not confer jurisdiction. That's my lord, fundamental point. Write a judgment, not a thesis, my lord. Sometimes, my lord, this is my word, not Honorable President's, my lord, view. It should not be an article to be published in some law review. It should be a judgment deciding the list between the participants. My lord, please come to page 245. Para 272. It is also vital to state here that for certain functions of the governor, the Constitution itself prescribes conditions for the exercise of power. Illustrations of such functions are enumerated below. Article 192, subarticle 2 provides that before giving any decision on the question of disqualification of a member of the House of Legislature, the governor has to obtain the opinion of the Election Commission. Constitutional mandate, this is how you will exercise your power. Functions under Article 233, 234 have to be exercised in consultation with the High Court. Manner of exercise of power stipulated by the Constitution. The governor has to exercise functions under Article 160, that is contingency function, in accordance with the provisions made by the President in that behalf. Again, manner of exercise of power. The power under Article 187(3) has to be exercised in consultation with the Speaker of the House. Under Article 2083, the Governor makes rules of procedure as to the procedure with respect to communication between two houses after consultation with the Speaker of the Legislative Assembly and Chairman of the Legislative Council. Again, manner of the exercise of power by the Governor controlled by the Constitution. Power under Article 258A has to be exercised with the consent of the Government of India. Article 316, 318, which deal with appointment, condition of service and removal of chairman and members of State Public Service Commission, also stipulate certain conditions, how he would exercise those powers. My lord, in fifth schedule also, my lord, I have not added this, my lord, but there is a tribal advisory council and he has to consult them. So, my lord, wherever the manner of exercise of power is to be circumscribed or to be stipulated, the Constitution stipulates. In my respectful submission, cannot be added by way of a judicial pronouncement. So that is, my lord, and there are other judgments, my lord, which I have cited. Now, my lord, I come to another important fresh question, whether the exercise of power of the President, either under Article 111, that is grant the power to grant assent, and that of the Governor under Article 200 and the President under 201, justiciable. Lord, there is a difference between power of judicial review and justiciability. And in my respectful submission, Lord, the view that it is not justiciable is supported by, Lord, more than one judgments, my lord, few of which are constitutional bench judgments, that these powers are not justiciable. Kindly bear in mind, all judgments have said that the power of assent, Lord, the title of Article 200 is power of assent, is a legislative act because the Governor is a part of the legislature. And otherwise also as a coordinate constitutional organ, the power is not justiciable. The exercise is not justiciable. My lord, that is the law. Lord, if I can come, invite your lordship's attention to page 248. Lord, when we say, in my lord, and kindly take this as a constitutional argument. In Britain, the concept is parliamentary supremacy. The courts cannot go into the validity of the law also. India, fortunately,
Except with human rights,
yes, with human, because of one particular act.
particular act.
That
Too only the Supreme Court.
only the Supreme Court, not other
Not the High Court.
and only on the ground of it not being compatible, incompatible.
Only with regard to their human right.
Yes,
They
human-
can't set aside legislation like the High Court in the India can do.
It is only a declaration, my lord. Even the legislation continues. My lord, that's the situation. But fortunately, my lord, your lordships, therefore, my lord, I always say that Supreme Court of India is the most powerful court in the world. Your lordships can set aside the parliamentary legislation, state legislation, any act, etc., constitutional amendment also, complete. But this is a legislative act, and it is act or a function of a coordinate constitutional organ. Now, my lord, in this context, my lord, I have divided, my lord, this is a major point, my lord. The rest of the points now, remaining points would be minor, but this would be a major point. Please come to page 248. My lord, we do not, I was just saying, my lord, that Britain has parliamentary supremacy. We have constitutional supremacy. We do not have judicial supremacy also. Parliament supremacy also. Nobody is supreme. All are sovereign in their respective fields. And in that background, the question,
Sovereign is the Constitution.
sovereign is the Constitution.
All three organs work under the spheres allotted to them by
To
the
them under the Constitution, and they are sovereign in their respective fields. But supreme is the constitution, unlike, my lord, parliamentary supremacy, which is accepted in Britain. Now, my lord, I have divided this, my lord, in this, my lord, points. Para 276. The nature of power and its justiciability. The Lordship gets, my lord, page 248.
Governor and president.
Governor and president. My president has two powers, 111 and 201, and governor has 200. While exercising justiciability of exercise of power by the president and the honorable governor under so-and-so, the submission is divided in the following categories. The nature of power and its justiciability, non-justiciability as a facet of independence of three coordinate organs under the Constitution. All the three organs have certain core functions or plenary powers which are reserved exclusively for each of the organ. But for example, Article 356 is the power of the governor, but it is justiciable. But there are certain functions which are core constitutional functions, my lord. And I will elaborate, my lord, and explain how, my lord, I distinguish them. Then judicial restraint and consistent view of this honorable court against judicial legislation, even when judicial review is undisputed, justiciability is variable. Even if your lordships have the power of judicial review, its justiciability would vary. Your lordships may still say that I have the power of judicial review, but for ABCD reasons, I will treat this to be non-justiciable. National security, etc., my lord, foreign policy, etc. One organ of the state under the Constitution cannot arrogate the functions.
You don't have to seek our permission.
No, but always do.
We have also said
We
that
have a tradition.
if we grant it to Dr. Singh, we have to grant it to everyone.
No, no,
Now,
no.
Mr.
There's
Singhal
a-
always follows the procedure.
I follow
the-
some
the
traditions, Mullah.
Tradition.
Some
My lord, one
traditions.
more thing I must say, which I learned from him, my lord, that during Constitution bench, he always sits throughout.
So that we have seen.
Yes, that is something, my lord.
Mullah, this is the tradition of the bar. If we just lose this also, we're left with very little.
Mr. Subramaniam is also sitting.
He is also
We always do that, Mullah.
Yes, Mr. Subramanian has been sitting, but we have done many constitution benches together, Mr. Sibal and me. Therefore, this is what I must admit, I have learned this, my lord, that this is a tradition which must be followed.
I'm obliged.
Except the comfort break.
Partly.
My lord, please see. Now, my lord, kindly come to my lord, haste, I have read, my lord. So I'll not read it, my lord. But no, I have not read, my lord, this hoist or haste, my lord, whatever. This paragraph, my lord, I have not read. I am on the
Who is silent? So next time you won't have problem here.
haste, yes, my lord, haste. Haste. Lord, why classical concept of judicial review will not apply, my lord, even if there is a judicial review, because of justiciability, because of the very nature of the function, my lord. And in that, my lord, haste pharmaceuticals, para 84, which I did not read because I read it for a different purpose, different point. Para 84, my lord, Justice Nassima would get it 250. Page 250 of my written submissions. So this is a judgment of 3 honorable judges. And your lordships may kindly bear in mind the title of 200 is assent of the governor. So it encompasses all options which are available with the governor. There was quite some discussion at the bar as to whether the assent of the president is justiciable. It was submitted that since not only subsection 1 of section 5 of the Act, which provides for the levy of surcharge on dealers having a gross turnover of rupees 5 lakh in a year, but also subsection 3 thereof, which interdicts that no such dealer shall be entitled to recover the amount of surcharge collected from him, are both relatable to entry 54 of list 2 of the 7th. There was no occasion for the governor to have referred the bill under Article 200 to the president for his assent. The challenge was that his act of referring the bill to president is unconstitutional. It is somewhat strange that this argument should be advanced for the first time after a lapse of 30 years of the inauguration of the Constitution. Immediate provocation for this argument appears to be an obiter dictum of Lord Diplock while delivering the judgment of so-and-so that the courts are not powerless when there is a failure to exercise the power of revocation of a proclamation of emergency issued by the ruler of Malaysia under section so-and-so of Internal Security Act. The ultimate decision of the Privy Council was that since by virtue of section 47(2) of that act, the security area proclamation remained lawful until revoked by resolution of both houses of parliament or by the ruler, it could not be deemed to lapse because the condition upon which the ruler had exercised the discretion to make the proclamation was no longer in existence. That being so, the decision in Teh Cheng Po case is not an authority. Lord, this is now Honorable Supreme Court, my Lord, says in haste. That being so, the decision of Teh Cheng Po is not an authority for the proposition that the assent of the president is justiciable, nor can it be spelled out that the court can inquire into the reasons why the bill was reserved by the governor under Article 200 for the assent of the president, nor whether the president applied his mind to the question whether there was repugnancy between the bill reserved for his consideration and received his assent under Article 254(2). There is no provision in the Constitution which lays down that a bill which has been assented to by the president would be ineffective as an act if there was no compelling necessity for the governor to reserve it for the assent of the president. A bill which attracts Article 254(2) or Article 304(b), where it is introduced or moved in the Legislative Assembly of a state without the previous sanction of the president, or which attracted Article 31(3) as it was then in force, or falling under the second proviso to Article 200, has necessarily to be reserved for the consideration of the president. There may also be a bill passed by the state legislature where there may be a genuine doubt about the applicability of provisions of the Constitution which require the assent of the president to be given to it in order that it may effectively be an act. The governor is confused whether there is repugnancy or not, but he errs on the safer side that there may be a repugnancy and refers. There may also be bill passed, any provisions with so and so. I'm sorry, Mother. Even if it is ultimately turns out that there was no necessity for the governor to have reserved a bill for the consideration of the president, still he having done so and obtained the assent of the president, the act so passed cannot be held to be unconstitutional on the ground of want of proper assent. This aspect of the matter, as the law now stands, is not open to scrutiny by the courts. In the instant case, the finance bill, which ultimately became an act in question, was a consolidating act related to different subjects, and perhaps the governor felt that it was necessary to reserve it for the assent of the president. We have no hesitation in holding that assent of the president is not justiciable, and we cannot spell out any infirmity arising out of the decision to give such assent. My Lord, now your Lordships may, my Lord, kindly take Kesare Hind, my Lord. Lord, this is, my Lord, 5-judge bench judgment, my Lord. Lord, can I begin at 2? It's almost, so that this is a few more paragraphs are to be read in this, my Lord.
Your Lordship, may I mention one matter for listing tomorrow? Fresh matter, Your Lordship. There is.
Before we go, so this is Mysore, not before this.
Oh, yes.
I would respectfully, my lord, request your lordships to take volume V17, 517, page 6664, 6664. This is Kesare Hind judgment, my lords. Sorry, not V, 5, Roman 5. My mistake.
Page
6664.
triple six.
6664. This is Kesare Hind, my lord, Constitution Bench judgment. I'll just read 3 paragraphs.
5-7. No, 17 में कुछ करा जाए.
Then triple six.
Kesare Hind
Kesare Hind, yes.
versus NTC. Yes.
Kesare Hind versus National Textile Corporation. Para 1, 2, and 3 is what the issue was before the court. Short, your lordship gets one. Para 1. Short but important question involved in these matters is whether the assent given by the President under Article 254(2) of the Constitution of India with regard to the repugnancy of the state legislation and the earlier law made by Parliament or the existing law could only be qua the assent sought by the state with regard to repugnancy of the laws mentioned in the submission made to the President for consideration before the grant of assent, or would it prevail qua other laws for which no assent was sought? Your lordships would mark 254(2) is just, my lord, the cause for exercise of 200. 254(2) says that if there is repugnancy between central and state law, then President would go under 200 and seek assent. The contention is, once the President grants the assent to the state legislation, the state law would prevail on the said subject, and such assent would be deemed to be an assent qua all earlier enactments made by the Parliament on the subject. The contention is negative for the reason recorded hereinafter. It is held that consideration by the President and his assent under Article 254(2) is limited to the proposal made by the state government. The state legislation would prevail only qua the laws for which repugnancy was pointed out and the assent of the President was sought for. Proposal by the state is a sine qua non for consideration and assent. Just to broadly point out, suppose the Honorable Governor feels that it is repugnant to 2 central acts and forwards, my lord, for the assent of his Honorable Governor. But it is found that it was repugnant to 5 central laws. What would be the effect of the assent? And one of the main questions which arose was, can the assent ever be justiciable? I'm sorry, my lord. Yes. My lord, kindly now come to para 23. Para 23, the 6673. The learned senior counsel, Mr. Nariman, next submitted that the assent given by the President is not justiciable and placed reliance upon the decision of this court in Bharat Srivastram Sangh versus State of Gujarat, wherein this court observed thus: it cannot be said that the assent which was given by the President was conditional. The records relating to the above proceedings were also made available to the court. On going through the material placed before us, we are satisfied that the President had given assent to the act, and it is not correct to say that it was a qualified assent. The act, which was duly published in the official gazette, contains the recitals that the said act had received the assent of the President on so and so. Moreover, questions relating to the fact whether assent is given by the Governor or the President cannot be agitated also in this manner. In haste versus so and so, this court has observed, we have no hesitation in holding that the assent of the President is not justiciable, and we cannot spell out any infirmity arising out of his decision to give such assent. My lord, now your lordships may kindly see, haste is again quoted, which I have read. I'll skip, my lord, para 25. In our view, for finding out whether the assent was given qua the repugnancy between the state legislation and the earlier law made by Parliament, there is no question of deciding validity of such assent, nor the assent is subjected to any judicial review. That is to say, merely looking at the record for which assent was sought would not mean that the court is deciding whether assent is rightly, wrongly, or erroneously granted. The consideration by the court is limited to the extent that whether the state has sought assent qua particular earlier law or laws made by the Parliament prevailing in the state, or it has sought general consent. In such a case, the court is not required to decide the validity of the assent granted by the President. In the present case, the assent was given after considering the extent and nature of repugnancy between Bombay Rent Act and Transfer of Property Act as well. President so-and-so. Therefore, it would be totally unjustified to hold that once the assent is granted by the President, the state law would prevail. No, that is on the facts of the case. Now, my lord, I would respectfully substantiate this submission, my lord, on the ground of doctrine of separation of powers and, my lord, on the ground that non-justiciability of constitutionally coordinate organs is a part of separation of powers, my lord. And that is how, my lord, your lordships have construed. My lord, if your lordships can now consider coming to another angle from which, my lord, this can be seen. My lord, suppose assent is granted as per the aid and advice of the Council of Ministers. There is no dispute between the governor, the view of the governor and the view of the council. My lord, Article 163(3) specifically prohibits the court from examining what advice was granted. Consequently, as a consequence, my lord, it would also prohibit the Honorable Court from inquiring why and for what reason the assent was granted. This is one facet. Second, my lord, suppose assent is granted, justiciability, my lord, according to two judgments, it's not justiciable. Suppose the Honorable Governor chooses the route provided under the proviso, that first I would send it back with a message, then even that would be subject matter of judicial review. After the proviso, my lord, operates and the bill is again presented to him with or without modifications, he may choose to refer it to the President. That again can be subject matter of judicial challenge. So therefore, my lord, my respectful submission, my lord, thereafter it would go to the President. The President also may again choose to send it back to the Legislature under Article 201. That again can be a subject matter of challenge. Thereafter, my lord, the President may grant assent. That would also be a subject matter of challenge. My lord, the question is, in the scheme of things, my lord, when the Governor and the President are exercising legislative powers, being part of the Assembly and the Parliament respectively, my lord, is such multi-pronged attacks by way of a judicial review is contemplated? And my lord, in my respectful submission, the answer is no. If your lordships can only come to, my lord, page.
So see, if the assent is granted
Yes, sir.
by the governor or the president, no question, because it becomes a law. If it chooses to go through the proviso, whatever, it is taken to the logical end. So either he grants assent or not.
Can I just interrupt here with your lordship's permission?
But if the governor withholds it for unlimited period,
No, Lord, again, I'm not repeating it. Withhold is permanent withhold. It's an act by.
permanent withhold, because
Yes.
from your chart, permanent withhold and temporary withhold.
Yes, yes, that can be, but that's a possibility.
Yes.
But, my lord, please see, my lord, the title of Article 200. It said assent of the governor. Assent is one. It has three facets: grant, withholding, reserving. So what, in my respectful submission, is not justiciable is exercise of powers under Article 200 and 201.
So according to you, 200 is totally beyond the scope of judicial review.
It's,
and justiciability.
my lord, it is not justiciable. Not similar, again, contrary to the.
Justiciable in the sense, it's a decision and decision-making process. The decision is not justiciable, that why the president or the governor has assented to. That cannot be, court may not examine it. The court can examine this aspect if there is a question of repugnancy or question of constitutionality of law will come. There the court will not examine the assent, the court will examine the very competence of the legislature.
And the act itself.
Itself.
Act itself.
Exactly. Here the question is of decision-making process, not the decision ultimately taken. So in the decision-making process, the court, as the rightly observed by the question bench, will call for the file, for what purpose the state had sought assent, to what extent, what were the laws. That process can be examined by the court. So it will fall within the ambit of judicial review. What is not justiciable is decision, assent, but process is.
Look, my difficulty is my difficulty means the difficulty which I foresee is multi-level challenges. For example, if grant of assent per se can be challenged, the option of the governor to send it, return it to the house also is a decision under 200. First option. That also can be challenged, that he could not have, because there is no repugnancy, or their governor can also send it without repugnancy.
That's also decision. It will not be challenged.
It cannot be challenged. That's my submission. Lord, suppose he chooses that I would refer it to the president for presidential assent. That is also a decision under 200. Lord, and all this, my lord, are isolated and independent powers, but can be exercised consequentially also. For example, Lord, a governor may say that right now I am not granting assent, I am returning the bill with amendment. The amendment may not be based upon repugnancy argument. He may just, the proviso say even desirability. The governor says that it is desirable that instead of, say, age is the subject matter. I am just giving a hypothetical example. Age is the subject matter. Then instead of 21 years of age, you are fixing, make it 25. It goes back. That is a decision, again, my lord, subject to challenge if your lordship holds that it is justiciable. Thereafter, my lord, the parliament, the assembly would return it with or without, my lord, the acceptance of his recommendation. Then also his option is available. If it is repugnant or otherwise required to be referred to the President of India, he can again refer it to the President of India. At that stage also, my lord, if it is justiciable, it can be put to challenge. Same thing would happen when the bill is received by the President of India, referred by. The President may again send it back to the House that I am suggesting something else, or according to me, the governor has not found it, but I am finding it, there is something repugnant, and I am returning it back. My lord, there is no prohibition. The President can do that. That is a decision under Article 201. Lord, again, that would be justiciable. Therefore, my lord, my respectful submission is that this being plenary legislative powers exercised by coordinate constitutional functionaries are, my lord, outside the pale of justiciability. Lord, because if it is a grant of assent, my lord, the question of, my lord, challenge will not arise, because then the act will be under challenge. Act can be under challenge, and there is no difficulty about it. There cannot be any argument. Lord, kindly have a look at page 254. First 253. Lord, I have read it, but just for ready reference, Council of Ministers to aid and advise the governor. 253. Lord, it is always, my lord, safe to save the jurisdiction of the court, and I am conscious of that fact. But, Lord, as it would, my lord, I would try to make it clear subsequently, Lord, this theory, separation of powers amongst coordinate constitutional functionaries, is a theory accepted in our constitutional principles. Therefore, in case of 200 and 201, Lord, it is, according to me, my lord, non-justiciable. Lord, please see 163, Council of Ministers to aid and advise the governor. But please see 3, the question whether any, and if so what, advice was tendered by ministers to the governor shall not be inquired into in any court. Kindly pause here for a minute, my lord, and let me give, my lord, one hypothetical example. My lord, the outgoing government has hurriedly passed a bill. It is sent to the governor. A new government is formed. The new government is not the same government. Some other party forms the government or some other leader becomes the chief minister. He may even advise the governor to withhold the assent, that now I would like to have a fresh mandate from the fresh electorate, from fresh assembly. Lord, the constitutional prohibition is what advice he has given you cannot go into. So in my submission as a consequence, what is done by the governor after that advice is also, my lord, non-justiciable. Court cannot go into it. Now, please see, my lord, page 254, State of Punjab versus Sodhi Sukhdev Singh, where, my lord, 163(3) came to be considered by the constitution bench of this court, my lord. My lord, only highlighted part, my lord, may be read. It is hardly necessary to recall that advice given by the cabinet to Raj Pramukh or the governor is expressly saved by Article 163, sub-article 3 of the Constitution, and in the case of such advice, no further question need to be considered. The same observation falls to be made in regard to the advice tendered by Public Service Commission to the Council of Ministers. Lord, then, next, my lord, 107, page 255. Under Article 163(3) of the Constitution, the question whether any and if so what advice was tendered by ministers to the governor shall not be inquired into in any court. In view of the constitutional protection and the reason underlying such protection, I hold that in present case, the district court was right in sustaining the claim of privilege. My lord, this article itself, my lord, gives an indication that there are some communications amongst inter se constitutional functionaries which are put by the constitution beyond the examination by the court. Constitution, my lord, Council of Ministers is also a constitutional body. Their communication with the governor, if it cannot be examined, my lord, then the governor's communication with the president also cannot be examined. And similarly, any exercise of power under Article 200 would be beyond judicial review, my lord, or rather would be just non-justiciable. I'll not use the word judicial review, non-justiciable. My lord, your lordships may, I'm just for reminding para 297, my lord, Kameshwar Singh and Valluri Chaudhary, my lord, Kameshwar Singh and Valluri Chaudhary, my lord, which I referred to, my lord, kindly come to page 255, para 297. Both have, my lord, held, both, my lord, 5 bench judgments, that exercise of power under Article 200 and as a necessary consequence 201 is legislative in nature. Lord, I have said Bihar versus Kameshwar Singh and Valluri Chaudhary, it has been noted that the governor and the president are part of legislature and assent powers are a part of legislative process. It is in this light that the question of non-justiciability must be examined. It is submitted that once a bill is resolved and receives assent, judicial inquiry into the propriety or necessity of such a reservation is restricted.
Commissioner Rose, I don't say it's a governor, not legislative. Commissioner Rose says that.
government or be government, the question is, my lord, as I have put it, my lord, in page 258, my lord, there are two issues. I'm not reading it. A, the 258, my lord. I'm not reading, I'm just, my lord, paraphrasing my submission. My lord, the decisions are polycentric in nature. The very nature of the decision is such that your lordships may perhaps not have any judicially manageable standard based upon which your lordships would examine. Existence or non-existence is one thing. Whether there is an assent or not is one thing. But if there is an assent would mean all options. Then, my lord, based upon what, I'm posing a question to myself, the court would examine whether this assent was rightly given or wrongly given. Second, my lord, there is a concept of constitutional committee. And the constitutional committee under our constitution is respect for one organ by the other organ. We do not have, my lord, hierarchical system that ultimately every organ's decision or conclusion would rest in one organ. There are checks and balances. For example, my lord, legislative act enactment is subject matter of your lordship's judicial review. It's not a hierarchical position, but your lordship's power of judicial review. Any decision taken by the executive, which is not a plenary constitutional power. The executive takes several decisions. My lord, the ministry, my lord, makes a policy. Ministry takes a particular decision. There are several executive functions, administrative functions. They are all subject to judicial review. But when it comes to constitutional plenary powers, more particularly of the nature which are legislative, my lord, justiciability should be denied, my lord. That is my respectful submission, my lord. My lord, on which, my lord, I am placing reliance upon one judgment, Indira Nehru Gandhi versus Raj Narayan. My lord, here your lordships have seen, my lord, a adjudication by the court by an enactment was sought to be, my lord, upturned. Please have a look at, my lord, page 258. My lord, I'm skipping through, my lord, most of the things. I'm paraphrasing it now. My lord, page 258. Para 313, my lords have.
Yes.
My lord, the Chief Justice has. Page 258, para 313.
313.
313, my lord. Indira Nehru Gandhi versus Raj Narayan. Para 577. There is ample evidence in the Constitution itself to indicate that it creates a system of checks and balances by reason of which powers are so distributed that none of three organs is set up, it sets up, can become so predominant as to disable the others from exercising and discharging powers and functions entrusted to them. Though the Constitution does not lay down the principle of separation of powers in all its rigidity, as is the case in United States Constitution, yet it envisages such a separation to a degree as was found in Ranasinghe case, so-and-so versus so-and-so. The judicial review provided expressly in our Constitution means Article 226 and 32 is one of the features upon which hinges the system of checks and balance. Neither of three constitutionally separate organs of the state can, according to the basic scheme of our Constitution today, leap outside the boundaries of its own constitutionally assigned sphere or orbit of authority into that of the other. This is the logical and natural meaning of the principle of supremacy of the Constitution. But no constitution can survive without a conscious adherence to its fine checks and balances, just as courts ought not to enter into problems entwined in the political thicket. Parliament must also respect the preserve of the courts. The principle of separation of power is a principle of restraint. My lord, it is not a prohibition. It is a principle of restraint. My lord, the very nature of the function, at the cost of repetition, my lord, I am respectfully urging, is such that it is entwined with political thicket. There may be 50 considerations weighing with the constitutional functionaries. for which your lordships may not have a judicially manageable standard to examine and decide whether it is valid or invalid. My lord, then next judgment, I'll read only the highlighted part, my lord. MP oil extraction versus state of MP. The supremacy of each of three organs of the state, legislature, executive, and judiciary in their respective fields of operation, needs to be emphasized. The power of judicial review of the executive and legislative action must be kept within the bounds of constitutional scheme so that there may not be any occasion to entertain misgivings about the role of judiciary in outstepping its limit by unwarranted judicial activism being very often talked of in these days. So this is 1997 judgment.
Now we are in 25.
Now we are in 2025, my lord, and now again, my lord, this discussion is going on. And my lord, mostly, my lord, your lordship's intervention has been, my lord, for the benefit, but sometimes, my lord, it is believed that it is in the domain of executive. For example, my lord, one of the high court, since I have appeared, my lord, without naming, virtually the COVID management was being monitored, my lord, administered by the high court. And all our officers who were supposed to be working on the ground were sitting in my chamber and we were preparing the status reports. What is the vaccine available? What are the number of companies which manufacture remdesivir, which each company has by way of their raw material? What is the production capacity? What is the production capacity of each company? In how many days, how many remdesivir drugs will be made available, etc., etc., etc. So, my lord, that is something, my lord, which is avoidable.
That is micromanagement of the government function.
Well, your lordships have always, my lord,
That will never interfere with it to, we can't ask you how a district is to be administered, how your collective could function. But suppose if particular function is entrusted to the governor, the honorable governor, and if for years together he withholds it, will that also be beyond the scope of judicial review of this court?
my lord, I would say.
When this court has set aside the constitutional amendment itself, which had taken away the powers of judicial review, that no amendment should be called in question by this court. It has been found to be hitting at the basic structure of the constitution. So, and with the judgment with those judgments, can we say that everything, however the highest constitutional authority may be, if it does not act, still the court would be powerless?
No, my lord. My argument, please do not misunderstand. My argument is not that the court is powerless. I am on justiciability. My lord, there is difference. There can be a power.
No, assent is given, not given. Reasons, we may not go into that as to whether the president was justified in giving the assent, as to why he has given the assent, as to why the governor has given the assent. But suppose if an act passed by a competent legislature, the honorable governor only sits over it, it could still be the courts.
Yes, I'll answer that, my lord, in two ways. First of all, your lordships would not decide whether there is any justiciable power in your lordship or not based upon an extreme situation, my lord, which may arise. That is my first answer. And second,
Like you said yesterday, the hard cases lay down a bad law.
bad law.
And my learned brother said that hard cases lay down a good law.
Hard cases always lay down a bad law.
No, no.
Not at all.
No such thing.
Lord,
They will agree with me and disagree with you.
Mr. Hari Vishnu Kamath agrees with
no,
Mr.
no,
Vikramnath.
my lord, he is a very respected person, my lord, but my lord, this is
In a lighter vein.
on the lighter vein, my lord, but this is like, my lord, a candidate celebrating based only on the Ruzan coming in the morning, my lord, and distributing sweets. But that's what, my lord, the other candidate would hope, that these are only Ruzan and not the real picture. So, my lord, your lordships would, my lord, in that case, my lord, even if the governor sits on the bill, the solution does not lie here. The solution lies elsewhere.
Where?
Solution lies in
Where,
the
where?
political sphere. These are all political decisions. Such cases do happen, and such cases are, my lord, solved through that democratic process. Lord, it is wrong to believe that there can be circumstances where every other organ would fail, and therefore the only available organ would be this organ. Lord, this organ has protected fundamental rights, and your lordships are custodian of the constitution, no dispute on that. But there are certain problems which are, my lord, not solvable by the judiciary. They are to be solved, my lord, by political democratic process. When such a thing happens, my lord, we have to expect and accept that there are constitutional functionaries who are responsible and responsive, because they are answerable to the people every day and at least every 5 years. In a
The honorable
situation like
governor
this,
is not answerable to anyone.
pardon me?
The honorable governor is not answerable.
Governor, my lord, I'll answer that. I'll answer that immediately. The governor is the most vulnerable office. He can be removed without anything else. My lord, the moment the chief minister goes to the prime minister or the president and look at the facts of this case, this is what has happened, and such things do happen. That when governor sits over it, my lord, for good reasons, bad reasons, no reason, whatever, then political process takes over. And governor can be called back. Governor can be, some other person can go as a governor. Why not, my lord? And why can we not trust other constitutional functionaries? It's a matter of, my lord, the chief minister talking to the other constitutional functionaries that we are facing a constitutional problem. My lord, whenever something happens, my lord, in the judiciary, I'm not giving, my lord, a comparative example. My lord, the system takes care of it. There is an inbuilt system, my lord. Every problem does not come here on the judicial side. Your lordship takes a decision on the administrative side. So every problem is not solvable under Article 32 or 226 and thereafter 136. There are problems, my lord, under, I'm sorry.
Solicitor, the constitutional immunity to some extent is clearly worded in what advice given by the governor. Polycentricity, decisions involved in such a decision making. Why an assent is given, why a withhold has taken place, and why he refers it to the president for his opinion with a message. All these stand on one footing, and there is a constitutional immunity provided to all those. But we are actually today in this case referring to the procedure prescribed, which stands on a completely different footing. As regards the procedure, where is the constitutional immunity?
There is no immunity.
Number two,
I'm sorry.
it is exactly in this very context that the Kesare hymn, what you have read,
Yes.
they drew the distinction, saying that whether there is no question of deciding the validity of an assent there, but whether it was with respect to one part of it, another part of it, to examine it, they will look into it, is what they said.
That, my lord,
Therefore, an inquiry which is to be made whether the constitutional process, as Honorable Chief Justice has said, constitutional process of granting, not granting, or referring not being done, to what extent any kind of an immunity applies unendingly is the question.
Lord,
So we are not on the merits.
I'm out. I have understood the question. First of all, I am not basing my argument on any immunity. No, there is no immunity from judicial adjudication of any dispute except those issues which are not justiciable. I am not saying, my lord, immunity. For example, the governor takes the decision of 356. Your lordships have even held such decisions to be mala fide in Bihar case. In case of Bihar, your lordships were, Bhutta Singh. But court said that he was acting mala fide. He is not immune.
He didn't use that expression immune. We are substitute it with judicial review.
My lord, I am putting it slightly differently, my lord, not even judicial review, justiciability.
Okay, put it in, replace it with justiciability.
Yes.
Then answer it.
Yes, my lord, justiciability, my lord.
Not.
Well, justiciability, my lord, flows.
Logjam then, and there be a logjam.
My lord,
You are saying that the only way to answer it is through political process.
my lord, every logjam may not have a problem, may not have a solution with the judicial. My lord. I'm with profound respect, kindly don't take this as an arrogant way of, my lord, putting it. I'm saying constitutionally, every problem may not have solution before the court. There are several problems where the problems will have to be sorted out as per the constitutionally prescribed democratic political process. And the court would be, my lord, holding its hands, my lord, saying that it is non-justiciable. We do not have any standards by which.
Our powers under 356 are for a temporary period. The president rules cannot be.
It can't be.
Then there are inbuilt safeguards.
Correct, my lord.
Within a limited period, it has to be placed before both the houses of the parliament.
Correct, my lord.
Then, if there is a dissolution, then
Election within a.
after 6 months, so in under 200, if we hold that the honorable governor has an unlimited power to withhold for time immemorial,
I'm just, my lord, just allow me to make the distinction. Article
then
3.
what is the safeguard for a duly elected legislature? Suppose a legislature which is elected by, say, 2/3 majority unanimously passes a bill. And we were giving example yesterday that if it is repugnant with the central act, then he may withhold it, or for some other reason, national security, so and so. If that be so, then if he doesn't exercise the proviso, it will be making the legislature totally defunct. The persons who are elected from that state, and if such a, it is not as if such a act is repugnant, then it is always subject to challenge. Or if it is contrary to.
Lord, may I answer? May I answer? Well, 356 is an executive power. It's not a legislative power, first of all. my lord. And therefore, my lord, there is.
To be ratified by the legislature, central legislature.
No, correct, my lord, but that's not the question here, my lord, is the decision taken in exercise of executive power under 356 is subject matter of judicial review. My lord, again, my lord, your lordship's concern is a concern that what happens, but the answer is this forum is not the solution. The solution is either amendment of the constitution, and till that happens, the political process, and such process does take place. Every state does not take a confrontation position. My lord, they do, my lord, exercise their my lord, diplomatic options, meeting, my lord, the constitutional functionaries. They persuade, my lord, discuss, debate. If there is some gap between one thinking and another, they try to bridge the gap, and ultimately the problems are solved. Your lordships are not flooded with state government saying that my bills are pending. So therefore, I am, my lord, repeatedly cautioning, my lord, not to examine the matter based upon some extraordinary or exceptional situations. Lord, now, my lord, I'll again come back to, my lord, page 259, my lord, State of Rajasthan versus Ramesh Chandra Mundra. Because here again, my lord, we would be creating a constitutional hierarchy that ultimately every problem will, the buck will stop here only, or for every problem in the country, which is not, my lord, in my respectful submission, my lord, the real heart and soul of the separation of power. Some problems are problem of a nature where the solution cannot be here. My lord, please come to, my lord, page 260. My lord, Kalpana Mehta. Lord, it again, my lord, talks of the separation of power. My lord, I'll not repeat it, my lord. I may not repeat it. Please come to, my lord, 264. And I'll just read 2 paragraphs and, my lord, move on. Lord, I have already pointed out that there are certain core functions core functions. But there are, for example, governor exercises several powers. There are certain functions which are core constitutional functions in the nature of a legislative function. There, the doctrine of separation of powers, my lord, the problems, I kindly pardon me for giving this example. It may not be a comparable example also. My lord, Supreme Court decides 100 cases, hypothetically, my lord, per month. There are several cases where they are changed in the curative jurisdiction. There is a possibility that even after curative decision, jurisdiction being exercised, some may feel that still we have not got justice. Somewhere, something will have to stop. The buck will have to stop somewhere. Look, the justiciability argument being met with that what happens if this situation arises is, my lord, in my respectful submission, my lord, ignores an argument that in every sphere of the constitutionally framed three organs, Lord, there are some issues where buck will have to stop somewhere. It need not be, my lord, it need not reach here, my lord. I'm sorry, my lord. I'm trying to phrase it the way it is possible. Lord, now kindly see, my lord. I'll skip, my lord, the rest of the things. And please come to, my lord, Aravalli Golf Club. My lord, I'm now on, my lord, other directions which are given 3 months period, give reasons. Lord, the Tamil Nadu judgment, the 3 months time fix, give reasons, and deemed assent. I'll come to, my lord, last point is deemed assent, whether there can be any conceptual concept of a deemed assent or not. And I have also enlisted the provisions where wherever the Constitution stipulated that in absence of a particular act, something will be deemed, the Constitution has provided. My lord, there is one beautiful passage, my lord, in Aravalli Golf Club versus Chendarhas. My lord, please see, my lord, the highlighted part only. Page 272.
270.
272.
The deem, opposition on deem?
No, no, my lord. Justiciability.
That's true.
Lord, restraint, judicial restraint, that every problem need not be solution here. They, my lord, they have used, my lord, one very popular statement of Justice Cardozo. Judges must exercise judicial restraint. Your lordship, Simon. Judges must exercise judicial restraint and must not encroach into the executive or legislative domain. Vide so and so. Under our constitution, the legislature, the executive and the judiciary all have their own broad spheres of operation. Ordinarily, it is not proper for any of these three organs of the state to encroach upon the domain of another. Otherwise, the delicate balance in the constitution will be upset and there will be a reaction. Judges must know their limits. I'm sorry, Mala, I'm reading the judgment.
Yes, yes, yes.
Must
You can read it loudly, no difficulty.
Why you feel sensitive? If you don't have,
Judges
then we
must
don't have.
know their limits.
Yeah, we also say that whenever a petition comes before us,
Your lordships have always, my lord,
That it is
the
the-
separation of power is, my lord, kept in.
yeah, whenever we don't want to name the petitioners, we show such direction to the Union of India to frame this law. We always say that it is within the domain of the legislature, it is within the domain of the executive.
Serial litigators, my lord, where we, as I say.
Something is done and the first petitions are filed with 2 or 3 pages, and so
Yes,
therefore,
my lord, so that the reported judgment,
so therefore the then Chief Justice came with this policy in Ray so and so.
Ray so and so.
Otherwise,
But that was suggested by me, that because there used to be a fight, that mine is filed first, but his petition is registered first by the registry. So, so therefore I suggested that instead that it should be Ray so and so. The judges must know their limits and must not try to run the government. They have modesty. But don't kindly ignore it. 21. The
no,
theory
you
of,
can read that. No, don't.
the theory of separation of powers first propounded by the French thinker Montesquieu in his book the spirit of laws broadly holds the field in India too. In chapter 11 of his book, The Spirit of Laws, my lord, I can skip Montesquieu. Kindly turn the page over, my lords. I'm sorry, my lords. My lord, page 274, para 30. Para 30, your lordships, my lords.
Yes.
The justification often given for judicial encroachment into the domain of the executive or legislature is that other two organs are not doing their jobs properly. Even assuming this so, the same allegation can then be made against the judiciary too, because there are cases pending in courts for half a century, as pointed out by this court in so-and-so. If the legislature or the executive are not functioning properly, it is for the people to correct the defects by exercising their franchise properly in the next election and voting for candidates who will fulfill their expectations, or by other lawful methods, that is, peaceful demonstrations. The remedy is not in the judiciary taking over the legislative or executive functions, because that will not only violate the delicate balance of power enshrined in the Constitution, but also the judiciary has neither the expertise nor the resources to perform such functions. Well, kindly turn the page, para 35. The constitutional trade-off for independence is that judges must restrain themselves from the areas reserved to other separate branches. Thus, judicial restraint complements the twin overarching values of the independence of judiciary and the separation of powers. In Lochner versus so-and-so, Mr. Justice Holmes, in dissenting judgment, criticized the majority of the court becoming a super legislature by inventing a liberty of contract theory, thereby enforcing in particular laissez-faire economic philosophy. My lord, kindly skip some my lord, part. In the nature of judicial process, Justice Cardozo remarked, and my lord, this, my lord, in my respectful submission, has withstood the test of time and is being quoted often. Justice Cardozo remarked, the judge is not a knight errant roaming at will in his pursuit of his own ideal of beauty and goodness. My lord, in Maratha reservation, my lord, also this is cited. My lord, my lord, knight errant, my lord, is kind of it's a fictional character which used to roam around at night, and whatever he thought is improper or illegal in the society,
Robin Hood.
he would correct it. So therefore, they say that this is something which should not be done. My lord, kindly skip the pages, my lord. Page 282. Lord, one organ of state cannot arrogate to itself the functions of another organ. My lord, this is, my lord, when we say if you don't do it within a particular period, there would be a deemed assent, or we would examine whether you had justification of not doing it in a particular way, not doing it on a particular time, etc., my lord, would be violative of, my lord, separation of power.
Para 38 also.
Para, my lord, 353.
38, page 275.
Oh, I'm sorry.
Moral of the story.
Page 27. I'm sorry. Para 38. The moral of this story is that the judiciary does not exercise restraint and overstretch its limits. There is bound to be reaction from politicians and others. The politicians, I avoid it. The politicians will then.
Why avoid it? It's in a print. Yes. It's in a print.
Sometimes, my lord, politicians.
Clearly, because Mr. Sibal and Mr. Dr. Singhi are here, it doesn't mean that we shouldn't read that.
No, they're respectable politicians.
So they are in the dual capacity.
No, even Mr. Wilson is here.
Yeah, Mr. Wilson is not to be seen. Mr. Reddy is also there.
Mr. Reddy is here, my lord. We have 3 MPs.
He was remarking, my lord, when he was mentioning about the parliamentarians, if Dr. Singhvi would be here when Wilson was there would have been 4 of us in a row.
And despite the parliament being in session, 4 of them are here.
That is how Parliament is adjourned now.
On the lighter side.
So the moral of the story is?
Your lordships have read it. But why? I'll read, but there is nothing. The moral of the story is that if the judiciary does not
May I
exercise.
just interrupt for 30 seconds? Whereas there is this about this parliament and this. Whereas Mr. Jaitley and I were coming out of the house, and Mr. Yechuri was also coming out. He had just given a speech in parliament asking for a law to prohibit doctors, lawyers, chartered accountants, and anybody else to be MP. So when we came out, both of us spontaneously told him, we said, Sitaram, you want parliament to be a community of unemployed and unemployables. This actually happened with us, and all three of us are together.
But I was on page 282, but please come to page 283. Lord, State of Rajasthan versus Union of India. Lord, this is a 7-judge bench judgment. Lord.
Mumbai total threat. Mumbai.
But this is precursor to Bomai. Bomai I will not read. I'll just paraphrase why your lordships would not rely upon Bomai, though Tamil Nadu relies upon Bomai. Well, just a bold part, but it cannot assume unto itself the powers of constitution lodges elsewhere or undertake tasks entrusted by the constitution to other departments of the state which may be better equipped to perform them. The scrupulously discharged duties of all guardians of the Constitution include the duty not to transgress the limitations of their own constitutionally circumscribed powers by trespassing into what is properly the domain of other constitutional organs. Questions of political wisdom or executive policy only could not be subjected to judicial control. No doubt, executive policy must also be subordinated to constitutionally sanctioned purposes. It has its sphere and limitations, but so long as it operates within that sphere, its operations are immune from judicial interference. This is also a part of the doctrine of rough separation of powers under the supremacy of constitution repeatedly propounded by this court, and to which the court unswearingly adheres even when its views differ or change on the correct interpretation of a particular constitutional provision. Then bottom, a scrupulous adherence to this scheme is necessary for the smooth operation of our constitutional mechanism of checks and balances. It implies due respect for and confidence in each organ of our republic by the other two. My lord, particularly when, my lord, we are dealing with the highest constitutional functionaries of coordinate organs, my lord, in their constitutional capacity, my lord, not in their executive capacity, in their plenary power, which is legislative in nature, my lord. My lord, similar are other judgments, my lord. I am not troubling your lordships with, my lord, may be treated as read, my lord. Lord, thereafter, my lord, I have said,
Even Bombay is not completely against you.
no, it's not.
Because
In fact,
even read this judgment in
it says there are manageable standards.
specifies what are outside the ken of.
Exactly, my lords. I'm grateful.
Some portion.
I'm immensely grateful, my lords. My lord, I have said, restraint in exercise of judicial power in case of high constitutional functionary is a facet of separation of powers, which is a basic structure of the Constitution. And therefore, such restraint and non-justiciability should be read as a part of basic structure of the Constitution, to respect the separation of powers. My lord, then page 285, that even when there are undisputed judicial review positions, my lord, that legislature, executive policy, etc., there are inbuilt self-imposed restrictions. My lord, judicial restraint is always a self-imposed restriction. My lord, now page 287. My lord, your lordships must have these judgments. I am not reading them, but world over, these are judgments from other jurisdictions.
But you always say that we should.
I am not reading them.
should only follow our jurisdiction.
Yeah, absolutely. Well, therefore, I'm not, I said that your lordships must have it, but without going into it, my lords. Lord, Thames cannot be more pious than Ganga, my lord. That is the or Mississippi for that matter. Hmm? Petoma, my lord.
What is-
Washington has Petoma. Anyway, my lord,
Krishna.
In the concurring opinion
in some concurring opinion of Samsher Singh, my lords. Lord, now please come to 304. मैं सर कोट किया which is Lord, I'll not trouble your lordships because propositions are known. Lord, there are 3 judgments cited in Tamil Nadu case for the purpose of justiciability. First is Bomai case, as my Lord Justice Narasimha has said, my Lord, and I respectfully, my Lord, take that, my Lord, that there the Honorable Supreme Court came to a conclusion that there are judicially manageable standards. This was not a case of assent. Bomai was a case of 356. And therefore, it was an executive act and there were standards, whether you could have done it or you could not have done it. And therefore, the judicial review was exercised. My Lord, I have quoted the relevant paragraphs of Justice Ahmadi, Justice Verma, Justice Yogeshwar Dayal, my Lord, but I don't wish to read them. My Lord, second judgment which is cited is, my Lord, Manipur Tribunal. My Lord, that 10th schedule. Lord, that again, my Lord, Speaker is a tribunal and therefore there is no dispute that he is amenable to judicial review. He is not functioning inside the house or as a... If we can have judicial review over that function of the president, why not this? My Lord, Maruram and Perari Vellam were cases where the Honorable President exercised purely executive act of pardon, which is subject matter of judicial review. And it was a case of Article 21 of a citizen. It was not, my Lord, a political question that way. Political, not in, my Lord, any derogatory sense. Political questions means questions arising out of functioning of a functional democracy in a quasi-federal constitution. My Lord, so these 3 judgments, my Lord, would not lead to any conclusion that it is justiciable. My Lord, Oysten Kaiser, my Lord, in my respectful submission, holds the field. Then your lordships may, my Lord, kindly come to Lord, page 321. Lord, 321, my Lord, raises question number 9. Raise, my Lord, which the Honorable President has, my Lord, sought your lordships' advice, is this. Are the decisions, my Lord, page 328, 321, sorry. Are the decisions of the governor and the president under Article 200 and Article 201 of the Constitution of India, respectively, justiciable at a stage anterior into the law coming into force? Meaning thereby, my Lord, this is a subset that it is still at the stage of grant of assent, withholding of assent, returning the bill, etc., etc. Can someone come and say that this act under Article 200 and 201 is unconstitutional? My Lord, please have a look at, my Lord. Para 410, my Lord. But I would only read.
Act under 20. Under 200, there is no act, still at the bill stage. So only when the assent goes, the act, and then, of course, act is...
Then the bill can be challenged on all grounds possible. Pardon, my lord?
Size of 200.
Yes, yes, ma'am. Act capital A.
No, but-
Yes, yes, ma'am.
But if there is no decision, you have framed the question.
Hmm.
Are the decisions of the governor and presiding president under Article 200 and Article 200 of the Constitution of India, respectively justiciable at the stage anterior into the law coming into force?
Yes, my lord. But law comes into force when
Assent is granted.
is granted. But before that, it should have been granted, should not have been granted, should not have been referred to the president, should not have been returned to the house. Because here, my lord, we have faced a case where at that stage, my lord, the court has said that assent is deemed to have been granted. Then this is possibly, my lord, for the, not possibly, 100%, first time where the act came into force with the assent granted by the Supreme Court of India. My lord, your lordships on this side and on that side have seen acts which starts with this bill having been assented to by the President or Governor of India with a order dated so and so. My lord, these acts in Tamil Nadu mentions in the Gazette the bill having been assented by the Supreme Court of India with a judgment dated so and so. The court has exercised its jurisdiction at a stage anterior to the law coming into force. That is, my lord. And only see, my lord, one para, my lord, 414. My lord, your lordships would now again go back to Quixote. Quixote judicial review is available. Correct, my lord? No dispute on that because Speaker is a tribunal. Still, 5-judge bench in Quixote says that no quitimate action is permissible. We can finally set it aside, but we can do nothing at an interim stage. My lord, please have a look at
That
this.
has been interpreted that any such order which prevents the speaker from exercising his powers would not be permissible, but any order by the court which enables the speaker to proceed further would be permissible.
Yes.
That Cameron David has been interpreted in so many judgments.
Yes, my lord. But my lord, point I am trying to make is that even where judicial review is undisputed, it is at a stage where the action is performed, the order is passed. Lord, please have a look for my satisfaction, page, my lord, 322, what my lord Quixote Holohan says, my lord, on this. Pella 110, only one para is, my lord, relevant.
Tamil Nadu was a reverse case, Mr. Solicitor. Here the complaint was that action is not being taken. That was completely reversal.
Correct, my lord, that is justiciability, whether court could have done something or not. Correct, my lord.
No, so therefore,
My lord,
we
this,
are not in an appeal of the judgment.
I am not,
Suppose what is in our minds from day one? If for 4 years,
my lord, that your lordships will have to remove while answering this question. My lord, your lordship's interpretation cannot be based upon one particular instance.
Honorable CJ is asking on hypothetical case. Let's suppose there is a, it's not in one state.
and you are saying that it's, at least I think we are having petitions from 2-3 states now.
Yes.
Kerala, then
West Bengal.
West Bengal, then Punjab.
Yeah, I was missing you.
Yes.
I was.
How can he be missed?
You here? No, there are fixed seats.
No, you objected to his petition on Monday itself, so.
Yes. And your lordship now knows why they were opposing reference to a 5-judge bench.
But then we said that whatever we decide here,
Certainly.
will
I am
affect
on
all
that.
these
That
matters.
was on the lighter side, nothing to turn on the merits.
The fallacy of this.
No, we quite appreciate whether a time bond program could be issued such a 3 months, 1 month, and then deemed and all that. But consider a situation where the governor is bound to either way grant asset, but if for 4 years just sits over, then what happens to the democratic setup of the government? What happens to the will of 2/3 of the majority of the legislature of that state?
I would not, my lord, like to answer, my lord, answer the way I am going to answer. But suppose, my lord, the precedent, my lord, as I'm at the cost of repetition, is
We are not talking about honorable president, we are talking about the governor.
the governor. I'm giving an example of a president of India where a citizen approaches him that my trial is pending since 10 years and the sessions judge is not taking up the matter, and my offense is punishable with only 7 years of imprisonment and my husband is in jail. Can inaction on part of the judiciary empower the president to declare him as having only undergone the sentence? It may not be a comparable example,
We don't
but
think
this
that
is
there
how separation of power.
This
This is how separation of power. This presupposes that every problem will have a solution only ultimately, Lord, at the doors of this court. And political solutions or democratic solutions are no solutions. Lord, there are solutions, Lord, problems in functioning of the constitution where, Lord, there may not be a solution necessarily by judicial adjudication. It's not necessary, my lord, to hypothetically believe that every solution.
No, we are not hypothetically believing it. We are having petitions at least from the fourth
No,
state.
I am saying something else, my lord, that necessarily presuppose a belief that ultimately we will have to solve every problem. My lord, and my respectful submission is there are problems where this may not be the only solution, or this may not be the solution. That's my respectful submission. I'll proceed further.
Like, for example, how political executive came up with 10 schedule. It's not a court's invocation. That's what you said.
Yes, ma'am.
10 schedule.
Parliament did it because there was a problem of ayaram, gayaram, as we say. Defection was rampant.
The preamble itself, preamble of the constitutional amendment itself begins with that problem.
Correct. So, my lord, some problems, the solution can come only from within the system. That is, my lord, the doctrine of separation of power. There are certain core legislative functions, there are certain core executive functions, there are certain core judicial functions. But at the moment executive tries to step in, the judicial domain, your lordships have restricted. And rightly so, on the ground of separation of powers. Well, that is how NJSC went. NJSC was, my lord, declared illegal. The entire political spectrum of the country was on one page. Unanimous. It was passed unanimously, ratified by the 2/3 of the state, but your lordships protected the separation of powers. That no, one person also from the executive would not be a part of the collegium. My lord, respectful submission is, my lord, the separation of power is a balancing act which balances the constitution. And it will have to be a two-way street. Some issues are non-justiciable, but that's the respectful submission. My lord, kindly come to 324. Is it permissible for the court, my lord, please, 324, and I'll just, my lord, orally argue, but I'm not reading it. Is it permissible for the courts, and this is a very, very important, my lord, question which the Honorable President wants your lordships as, my lord, guidance on. Is it permissible for the courts to undertake judicial adjudication over contents of a bill in any manner before it becomes law? My lord, why this question?
I think
It does that question, it doesn't.
I'll
provide
tell
the
your
court-
lordships why it has arisen. What is, my lord, the scheme of the constitution? The governor assents the bill, withholds the bill, or refers it to the president. Forget two options. Forget fourth option. He refers it to the president. The question has arisen where there is a two-judge bench judgment which says that it is prudent for the president, before granting assent, to make a reference under Article 143 of the Constitution to this court, because the question of repugnancy is a legal question. Meaning thereby, the president will come before your lordships by way of a reference that I have received these many bills from the state. Kindly take that direction. and it is otherwise imprudent for me, as the Supreme Court has said, to take decision on my own, and therefore I am now requesting you to tell me whether it is repugnant or not. It proceeds on two fundamentally flawed assumptions. A, the Honorable President, or in this case, Honorable President, is unable to decide for herself whether there is repugnancy or not. And number two, your lordships will examine the bill at a stage anterior to it being an act and decide whether there is any repugnancy or not. And if your lordship says no, you grant assent, then the president will grant an assent. My lord, do we have a dual structure where before granting assent to a bill, unless the president is herself or himself, my lord, is of the opinion that we need opinion. My lord, there are 2 or 3 references made on the bill that I would like the Honorable Supreme Court to examine and guide me. But otherwise, do we presume that president will not be able to on her own take a call, and therefore it is prudent that president in every case comes before the court under a reference with 143, my lord. I'll just read it, my lord. Your lordships need not open. Whenever in exercise of powers under Article 200 of the Constitution, a bill is reserved for consideration of the President on grounds of patent unconstitutionality, they are of such a nature so as to cause peril to the principles of representative democracy, the President must be guided by the fact that it is the constitutional courts which have been entrusted with the responsibility of adjudicating upon the questions of constitutionality and legality of an executive or legislative action. Therefore, as a measure of prudence, the president ought to make a reference to this court in exercise of his powers under Article 143 of the Constitution. So before the bill becomes an act,
This is, that's question number 12. We will examine that 12 in that context. But this issue relating to examining the bill at a bill stage is consequence of that question. This question doesn't
12.
stand on its own. This 12 doesn't stand on its own for the reason that nobody
Because
is asking
He
the
has
bill to
framed
be
that
examined.
question, he has framed that question because of those observations.
This is it's coming before.
Before the president decides whether to grant assent or not,
Lord, kindly,
he should give our.
Lord, kindly see,
Consequence of.
Lord, kindly see the, my lord, hazard of this. Now, kindly see the hazard.
I would readily agree with you that what should be the answer to that question.
Kindly see the hazard. My lord, kindly see the hazard. I'll give a simple example, my lord, and there is no answer to that example.
I don't think that they would be opposing.
They would be, my lord. Let me place it. Let me place it. Lord, suppose
Civil as
they
started
should,
his first file.
no, they should not, because it's not a government or B government.
No, rewriting the constitution.
Yes, Lord, the difficulty would be this. Lord, if in every case the president as
Then we'll have to leave all other work and only devote ourselves to giving advice to the honorable president under 143.5,
Lord, the
145.3.
Lord, the difficulty would be, it would be a matter between your lordships and the president. There would not be anyone else. Your lordship says that no, there is no repugnancy.
No, but then under 145.3, we have to sit in a bench of 5 for giving that opinion.
Minimum 5.
Minimum 5 years.
Well, minimum 5 is when the constitution was framed, where the total strength was 7 judges. It is that, my lord,
Now, you want to make it 21
At least.
difficulty is, my lord.
out of 34.
My lord, difficulty is, my lord, suppose the president comes before the honorable president, requests your lordship's opinion. Your lordship says either way that it is not repugnant. But I am a citizen of India. I am affected by that act. How do I challenge that act before the High Court? Because it is already got an approval from your lordships at a pre-act stage. Therefore, my lord, this question, I will not labor it, my lord, beyond a point. Then, my lord, may kindly see, and another point, my lord, which just for the purpose of stating, my lord, Article 143 is an enabling or empowering provision. It's
a
not a,
discretion of the, it's a discretion of
it's
the
a
president.
discretion. It's not a
Whether,
mandate.
whether the president wants to seek
Justice.
advice or not, it is for her or him to decide.
Advice can, is always a discretion, whether to take advice.
Less the president making a power, more a justice doing power.
Yes,
That's what actually he.
it's an
invoked.
enabling provision, my lord.
Invoke that for the when he invoked that for
Okay.
doing justice.
No, that is what, my lord, I have page 327 is this question. I will not labor much on this. In page 327. In light of the constitutional scheme governing the powers of the president, your lordship gets. And my lord, I am not arguing as an appeal.
These are all connected, all these three are
I am
connected.
not arguing an appeal because this question is likely to arise now. Therefore, I am, my lord, before your lordships under 143. It's not an intra-court appeal. The argument from the other side would be that you will be sitting in appeal.
So
I am
that,
not.
that preliminary objection has already
yes.
been heard.
Yes. So then, my lord, your lordships have seen, my lord, the question. My lord Justice Nasim has seen.
Opening of that.
Please come to page 370 directly.
370.
370. So this is deemed assent. Whether there can be a deemed assent, this is a facet of Article 142.
Seventy or?
370.
370 of the submissions,
370.
of the submission.
Lord, this is a limb of Article 142. Your lordships are aware of Article 142. Lord, I am not citing any judgments, my lord. I have quoted, my lord, for your lordship's ready reference, but deemed assent is granted, my lord, under Article 142. The question is, my lord, this honorable court substitute itself in place of another constitutional functionary and do what the constitution requires that another functionary to do. Deemed assent would mean your lordships substituted your lordships as the governor, and your lordships declared that the assent is deemed to have been granted. Lord, on this, my lord, please come to page 375. Lord, 142 cannot be used to amend the constitution. My lord, forget deemed assent for reading time limits, for directing time limits, for directing a manner of exercise of power, etc., is not part of Article 142. That is my respectful submission. That your lordships have used, my lord, to do complete justice when there is a cause, when there are two parties, where there is no other constitutional or legal solution, but it can never be used to amend the constitution. And so far as deeming is concerned, please come to page 375. We have collated the provisions of the constitution wherever deeming is provided, contemplated, the constitution provides that if this doesn't happen within this time, it is deemed to have happened. That only the constitution can do, and not, my lord, under 142. My lord, the one question, my lord, Justice Narasimha initially said, my lord, that Article 32 and 131, that your lordships may perhaps not like to answer that question.
I should have, sir.
No, but that can be kept open. I have no difficulty. Otherwise, we can assist your lordships.
Issues can't go under 226, sir. It must go under.
Whether a state can file a petition under, when there is a.
The last issue,
Yes.
last question that are posed to us.
397, my lord.
Read that.
Because this is a federal dispute between state and the center. Of course, through president and through governor, but ultimately